that you will last potentially up to 3 hours or so.
Yes.
That's fine. I say to you, as I did to others, take a break when you feel you need one. If you need 2 breaks in that period of time, you won't have any complaint from me. So pick your moment, we'll take a break and then proceed again after a short 10 minutes or so.
Much obliged, Mr. Chairman.
Thank you. Yes.
I can start, Mr. Chairman?
Yes, please do.
Yes, yes. Good morning, Mr. Chairman. Chairman Jerome Lynch Casey and Commissioner Gregory Wilson. As counsel to the Commission and on behalf of my team, Mr. Ronnie Bisessa and Ms. Vijaya Maharaj, I wish to thank both of you for so expertly managing the procedural and now this evidentiary hearing, and for your helpful and instructive directions so that the public has complete access to all the evidence and documents which are before the Commission. I would like to give special thanks to you, Mr. Chairman, for the leadership you have provided to this Commission in ensuring that the commitment you gave to the public that the inquiry would be completed expeditiously has been kept. This Commission is historically significant because it's the first, as far as I'm aware, locally, that has uploaded all of the documents, correspondence, orders, and directions online, consistent with the access to justice principle. Further, all of the proceedings have been broadcasted live on national TV and streamed, and the public has, by their social media comments, followed the proceedings with great interest. This is one of the most important public commissions of inquiry held in Trinidad and Tobago. The Cabinet of Trinidad and Tobago recognized that these facts demanded a public inquiry, and a wide section of members of the public have participated in the hearings before this commission and have followed the events at the Commission of Inquiry. I am sure that the public is anxiously awaiting the report of this Commission of Inquiry, and that the government would lay that report in the Parliament of Trinidad and Tobago. This commission has advised that a final report is likely to be presented to the President by the 30th of April 2023. This has suggested a 9-month gestation period from your appointment as chairman, which is, as far as I'm aware, one of the quickest, if not the quickest turnaround in the history of the Commonwealth. The Commission's work was greatly assisted by the Secretary, Ms. Sarah Sinanan, and the Commission staff. And on behalf of the legal team assisting the Commission, I wish to express our gratitude for her and her team's support, diligence, and enthusiasm. The Commission's deliberations were also assisted by the various counsel for the parties given standing and others who attended on behalf of witnesses, and the legal team is also grateful for their respective contributions. I also wish to thank the members of my legal team, Mr. Ronnie Bisessa and Ms. Vijaya Maharaj, for their complete devotion and assistance to me in performing my functions as counsel to the Commission. Finally, I also wish to thank the persons behind the scene who, through their individual initiative and diligence, have helped to prepare the venue and have taken us to this point where the evidentiary hearing is likely to be closed today, or would be closed today, if I may say so.
Yes.
The structure of my submissions is as follows. Submissions have been made on how the contract and permit to work procedure ought to be interpreted, and whether the permit to work procedure is part of the contractual obligations of the parties. I would first respond to those issues in order to show that the permit to work procedure imposes contractual obligations on the parties. I would then deal with the non-delegable common law duty of care by Paria to ensure that measures were put in place for the works to have been done safely, having regard to the inherently dangerous nature of the works. These established principles of the common law were recently applied by the High Court of Trinidad and Tobago in a reported judgment. I would then refer to the works on the 25th of February 2022 to show that there were serious breaches of the contract and the permit to work procedure by both LMCS and Paria. Then I would deal with the LMCS documents, which include the method statement, risk assessments, job safety analysis, and emergency response plans, which were submitted to Paria and which Paria reviewed and accepted, and in which both Paria and LMCS did not identify that a delta P hazard could have occurred in the method of the execution of the works. Those documents were reviewed by Paria, accepted by Paria. Paria, in its evidence before this commission, however, admitted that it did not have the competence and expertise to do so. Notwithstanding that, Paria did not appoint an expert client representative to assist it in that review, and accepted those documents without doing so. The failure of both Paria and LMCS to identify the risk of a delta P event in the execution of the works was the root cause of the accident. I will then deal with the line clearing. The underlying factor which led to this accident was the removal of the line contents of Sealine 36, both in terms of quantity and the method used. This caused a gaseous void in the pipeline, which created a latent delta P hazard when the habitat was installed. That latent delta P hazard was activated when the inflatable plug was removed, which caused the seawater to flood the habitat and the vortex to be created, which sucked the 5 divers into the 30-inch diameter pipeline. I would then deal with the post-accident response by Paria and LMCS. There was no emergency response plan in place because the emergency response plan, which was submitted by LMCS to Paria and which was reviewed and accepted by Paria as a suitable emergency response plan, did not identify a delta P hazard. Consequently, there was no plan in place on the 25th of February 2022 when the latent delta P hazard in respect of the works was activated and caused the accident. I would summarize the evidence of the efforts made by both LMCS and Paria to show the efforts made by both of them to rescue the divers from the pipeline in the context of the limited time which they had to rescue the divers alive from the pipeline. I would then address the evidence of the treatment of the relatives following this tragic accident, and I would then address the Commission on the proposed recommendations.
Thank you. That sounds good.
First, I would just say some of the principles of law which govern the assessment of the evidence in this matter. And I may say this, Mr. Chairman, I would not refer to cases or references. I would just make the submissions. It would be online afterwards with my submissions, and I suppose all can see the references.
Yes.
Where a tribunal has to determine questions of fact, where there are disputed facts, the courts have held that in determining the credibility of witnesses, it is essential that the tribunal weigh their credibility against important contemporaneous documents. In other words, the credibility of a witness must be put correctly into the scales of the important contemporaneous documents and weigh the evidence against those documents. It is a well-established principle of law that where a party without reason fails to call a witness or witnesses that would be expected to be called, if that party's evidence would be favorable to that party, it would be open to the court or tribunal to infer that that person's evidence would not have helped that party's case. The same principle applies to the failure of a party to produce documents when it might reasonably be expected the party ought to have produced those documents. Any inconsistency between a witness's evidence and an earlier statement goes to credibility. Where a witness gives evidence which is inconsistent with previous evidence given on oath or previous statement, a tribunal can regard the evidence of that witness as unreliable unless the witness gives a reasonable explanation for the inconsistency. I would first deal with the scope of works in the context that it has been stated a lot in this case that this contract resembled the 2020 contract between Paria and LMCS. The scope of works developed by Paria for the contract works is at CB2, page 564. It was prepared based on the scope of works which had been done for a 2020 project completed by LMCS Berth 5. Both the 2020 and the 2021 projects involved the changeout of subsea piping. The main difference between the 2020 and the 2021 projects was that the 2021 project involved additional works above the sea, and further the leak in the subsea line was about 5 or 10 feet deeper. In dealing with the scope of works for the 2020 project, which is contended to be similar to these works, Paria employed a project engineer who developed the scope of works and oversaw the execution of the whole project. The scope of works for this project, CB 2564, refers to an estimated volume of product between isolation points between 2,000 barrels. Paria's evidence is that this represented an estimate of the volume of the product in the subsea line between berths 5 and 6. The evidence of Paria was that neither the scope of works nor the method statements required the underwater pipeline between berths 5 and 6 to be completely drained. Paria's addendum 1 to the scope of works at core bundle 598, query 1 states, who is responsible for pumping back from the berth to clear the lines with water? And the response is the contractor is responsible for the safe removal of hydrocarbon contents from the line and to ensure that the line is clear and dry. Paria's evidence, however, was that this meant that only part of the line where the works were to be carried out would be clear and dry. We shall demonstrate, however, when addressing the issue of line clearing later in our submissions, how the evidence of Paria's witnesses that the pipeline was not meant to be completely drained is inconsistent with the contemporaneous documentary evidence in respect of the line draining. The scope of work also sets out the contractual responsibilities of the parties. The contractor is required to provide competent supervision at all times during the execution of the job. They are also required by Section 5.4 to provide live video feed stream during the subsea works. At paragraphs 3.1.11 and 3.1.12, reference is also made to the provision of a video stream being provided topside during work activity for Paria representative. Paria responsibility are at Section 4 and include, among other things, supplying all work permit certificates, thereby recognizing that permits to work are to be issued before works, monitoring contractors' performance and work standards, approving work to be done by the contractor, and carrying out quality assurance audits, provide slop barges to assist in the removal of line content, provide personnel to oversee isolation, de-isolation, depressurization, pressurization, draining, filling product from lines at berth 5 and 6. Response to submissions of Paria and Counsel in respect of the contract. In response to their submissions that there was no evidence that the permit to work procedure was a contractual obligation under contract, we submit as follows. Firstly, Section 2 of the permit to work procedure under the heading Scope states this permit to work procedure applies to contractor, maintenance, civil, inspection, and turnaround related activities. Secondly, it is clear from Section 8 of the scope of works that contractors are contracted personnel and contracted personnel are required to follow the permit to work procedure and standard work instructions at all times. There was therefore a contractual obligation that the permit to work procedure would apply to the contract. Thirdly, According to the evidence of Mr. Randy Archibald of Paria, it is clear that the permit to work procedure did apply to the contract. At paragraph 11 of his witness statement, he stated that the permit to work procedure applies to contractor maintenance, civil inspection, and turnaround related activities. And at paragraph 12, he stated that during the execution of the contract, several permits to work were issued to LMCS by Paria. Fourthly, it is clear that the permit to work procedure sets out the roles and responsibilities of a contractor official. At section 5.6, we address this next when dealing with the permit to work procedure in more detail. Paria had a common law non-delegable duty of care, and the permit to work system was therefore designed to ensure that that duty was carried out, regardless whether or not an independent contractor was retained. In these circumstances, both Paria and LMCS had a joint and concurrent duty of care to ensure that the works which were inherently dangerous were carried out safely. We will also address this later in these submissions. Sixthly, this is not a civil case in which there are pleadings. It is an inquiry governed by the terms of reference. If Kenson's position is that evidence ought to have been led to show that the permit to work procedure is not incorporated as part of the contractual terms, Kenson had a duty, or Paria had a duty, to lead that evidence or cause it to be led in relation to that issue. Permit to work procedures. Paria has a control of work system which controls the works to be done and how they are to be done. The system includes the permit to work procedure. According to Terence Rampasad Singh, the control of work system not only includes the permit to work procedure, but everything from the operations department notifying the maintenance department of the need for the job to the signing of the contract. He stated that all of this is part of the control of work system, meaning that if work is not supposed to be done, it isn't done. Mr. Randy Archibald, in his witness statement at paragraphs 10 to 11, states, the permit to work procedure was developed to provide a formal, documented process for controlling risk associated with certain work activities, such as contractors and maintenance work. Without a permit to work being generated, no work can be undertaken by a contractor. The procedure intended to, among other things, 1, establish the requirements for identifying critical information on jobs, such as the nature and extent of the work to be done, the exact location of the job, the equipment to be used, the hazards involved, and the precautions to be taken. 2, prevent incompatible work from taking place simultaneously. 3, clearly identify who makes the application to do the job, who authorizes the job, who develops the necessary precautions, and who gives approval for work to commence. 4, ensure that work is not carried out unless there is proper authorization. 5, clearly identify high hazard work and the requirements, precautions to be followed. And 6, establish monitoring and auditing requirements for permits jobs. The following is established in the permit to work procedure. Wherever work is to be done within Paria, the operations department makes a request to the technical and maintenance department for the specific work to be executed. The technical and maintenance department then plans the works in conjunction with the operations department. Before the work can be started, all of the requirements of the permit to work system must be followed. This includes that work does not start until the work permit is properly issued and authorized. All persons on the job must receive a briefing from the appropriate supervision on the works to be done, and all persons on the job must understand the precautions to be taken before they start to work. Section 5, including Section 5.1 and 6, deal with the roles and responsibilities of key personnel under Paria's permit to work procedure, and they include the following. The applicant is described in Section 5.1 as the person who initiates a job by completing Section A of the permit to work. He must have the necessary competence to execute the job or to supervise the execution of the job, and he shall be knowledgeable of the hazards associated with the job and for the safety of the people who work on the job. His functions include, among other things, 1, to continually monitor the job to ensure that it is performed in a safe manner and within the conditions within the conditions prescribed in the work permit, certificates, and JHA risk assessment. To stop the work if there are changes in the site conditions that increase the risk, or if new hazards are identified, and promptly notify the site authority of these changes. It has been submitted on behalf of Paria that since the applicant was a Counsel employee, that Paria was not the applicant to the permit to work. This submission is wrong for the following reasons. The evidence shows that although Counsel persons were employed with Counsel, they worked at Paria. They had their offices at Paria. They took instructions and directions from Paria personnel and were subordinates of Paria officials. Majad Singh admitted in cross-examination that he was representing Paria to ensure there was a compliance with the works being done by LMCS and had a duty to stop the works if the works were not being done in accordance with the work permit. Majad Singh also admitted that he took instructions from Paria. He works at Paria and Paria tells him what to do and how to do it. Terence Rampasad Singh, Paria's then maintenance planner, stated that Mr. Majad Singh was his subordinate, that he took instructions and directions from him, and that even though he was employed by Counsel, he worked at the maintenance department of Paria. Also, the submissions on behalf of Counsel to the Commission in this inquiry, which agreed with this position, that is, the submission made by Mr. Pigas agreed with that position. In any event, any issue concerning the relationship between Counsel and Paria is an issue between them and is not a matter for this Commission of Inquiry. Competent person is described in the permit to work rules at section 5.2. The site authority is described in section 5.3, which includes that it ensures that a suitable and sufficient JHA has been prepared for the job. Specifies on the permit any precautions to be taken during the work. Periodically monitor ongoing work, either in person or through his team, to determine whether site conditions and precautions have been maintained. Suspends the job if unsafe conditions have developed or are likely to develop. The area authority is described in section 5.4 of the procedure, and its duties are stated therein. The senior authority is described at 5.6, and the contractor official is described at section 5.8. It is clear that the permit to work procedure is part of the contractual terms and obligations of the parties and are binding on them. The permit to work rules are also consistent with Paria's obligations at common law, having regard to the inherently dangerous nature of certain type of works undertaken at Paria's site. Non-delegable duty in common law. The general principle is that an employee, being Paria in this instance, is not generally liable for torts committed by his independent contractor, being LMCS in this instance. However, that ordinary principle is displaced where the law imposes on employer, Paria, a non-delegable duty, not merely to take care, but to ensure that care is taken. In one of the cases referred to, decided by the Supreme Court, under non-delegable duties of care, it's stated, the expression non-delegable duties of care is commonly used to refer to duties, not merely to take personal care in performing a given function, but to ensure that care is taken. The expression thus refers to a higher standard of care than the ordinary duty of care. Duties involving this higher standard of care are described as non-delegable because they cannot be discharged merely by the exercise of reasonable care in the selection of a third party to whom the function is in question is delegated. Such a non-delegable duty arises where the employer, Paria, employs an independent contractor to execute inherently dangerous work from which in the natural course of things, injurious consequences or others must be expected to arise unless measures are adopted to prevent such consequences. In such consequences, the employer, Paria, cannot relieve itself of its responsibility by proving that he had delegated the performance of his duty to a contractor, LMCS, employed to do the work, however competent the contractor may be, or even if the employer regards the contractor as a specialist contractor, where the work which the independent contractor is employed to do is of a character that is inherently dangerous unless done with proper precautions. The employer is responsible to anyone who sustains injury in consequence of the manner in which the work is done. It is to be noted that under Section 5.1 of the Permit to Work procedure, it is stated that the applicant shall be responsible for the job and the safety of the person who work on the job. Not only, and it's my comment, not only persons who are employed with Paria. And I put the authorities there, and I have quoted a few authorities there, Mr. Chairman, which I would not refer to. It will be on the record. It spanned a few pages. And then I submitted at, and I show that at paragraph 45 onwards that there could have been a there could have been a bargain with the contractor that he shall perform the duty and stipulate for an indemnity, etc. I should mention that at the end of paragraph 45, these cases were all referred to in a local high court case in CV 2015-03381, Ray Cheddy and another, a National Infrastructure Development Company Limited, at paragraphs 100 to 107.
Yes, I've seen that case. That's the one where the road building affected somebody's property.
Yes.
I note that it took them 8 years
Yes.
to secure any compensation.
Yes, madam. It is submitted that on the evidence, it is clear that the scope of works which LMCS was required to perform was inherently dangerous and could have resulted in injurious consequences unless appropriate measures were taken to avoid a differential pressure hazard. Based on these governing principles of law, it is clear that Paria in the circumstances had a common law duty of care to ensure that those precautions were taken. Having regard to the extent of the duty of care imposed on an employer who employs an independent contractor to do inherently dangerous works, the employer has a duty to employ competent experts to ensure it discharges that duty. So
can I ask you, is that submission that the employer has the duty to employ competent experts in addition to the contractor?
Yes.
Yes. So
yes.
they employ a specialist contractor. Your submission is that the employer had a duty nonetheless to employ some independent contractor who could assess that work.
Because the employer has to protect his obligation also in the duty of care.
And that arises quite independently of
the permit to work
of the permit to work system.
Yes. I was about to say that.
Right. Thank you.
I now go to works on the 25th of February 2022. LMCS contends that the removal of the plugs formed part of the work plan for the 25th of February 2022 and relied on the method statement attached to the permit to work, whilst Paria contends it was not part of the work plan and relies on the fact that the permit to work does not list the removal of the plugs as a task to be done and stipulates that the migration barrier was to be used. Jonathan Ramdan was the site authority and pursuant to the permit to work procedure and the person who issued the work permit. Mr. Ramdan in his witness statement stated that he was not trained, nor did he possess the expertise to assess the suitability or sufficiency of the JHA-JSA, even though this is one of the duties of the site authority. Mr. Ramdan had a duty as site authority to periodically monitor ongoing work, either in person or through his team, to determine whether site conditions and precautions were being maintained. He also had the duty to suspend the job if conditions were unsafe. Mr. Ramdan, in cross-examination, confirmed that he has no qualifications or experience in subsea work. He fulfilled this responsibility by posting Mr. Kirk Scott at Berth 6 on the 25th of February 2022. In cross-examination by the Commission Counsel, Mr. Ramdan stated that Mr. Kurt Scott was posted at the site to periodically monitor to determine whether the site conditions and precautions to ensure operational safety were being maintained. He stated that the migration barrier was a precaution, but there was no way to monitor the barrier because in order to monitor it, you would have to dive and go into the chamber. It is clear, however, from the evidence of Kurt Scott that he saw topside live footage of when the mechanical plug was being removed, but did not have the knowledge or experience to identify that this was part of the migration barrier, which was stated by Mr. Ramdan on the permit to work as a precaution which was to be used. So if he had that training and knowledge, he would have known then that it was not being used.
Their case though is that that wasn't his job at all.
At all, but
No,
but according to the permit to work system, it was.
His job or Mr. Ramdan's job?
Well, Mr. Ramdan delegated that job to him, and he was also employed by Paria. So Mr. Ramdan and Paria cannot say it is not responsible by delegating the job to a further incompetent person.
Yes, I mean, he didn't even know what the scope of works were, really, did he?
Yeah.
Fairness to him.
Yeah. At day 5, page 228, lines 19 to 25 on the 6th of December, his evidence was as follows. Question: Did you see them on the screen? Well, you saw the pipe they were working on? Answer: yes. Taking out something from the pipe? Yes. What you saw they were taking out? First, I saw they were working, moving some bolts from on the blank, right? And during another period, because every time I pass, I would take a look. I saw personnel operating a chain blow and turning something. Question: turning something? I wonder if the witness can see the mechanical plug on the screen. I want to show you on the screen something, and you will tell me if you recognize it. Answer: yes. Was it something like that you saw them working on? Answer: something like that I saw them take out the pipe. The mechanical plug was removed before lunch on the 25th of February, 2022. And that is from the evidence of Mr. Budram. And according to Mr. Budram, it involved the use of a spanner to remove 22 bolts and took over 30 minutes to remove. It is clear, therefore, if Mr. Kurt Scott had the necessary competence and experience to monitor the works on behalf of Mr. Ramdan as site authority, he would have been able to stop the works when the mechanical plug was being removed.
But isn't the evidence that even if he wasn't site authority, anybody, the T-boy, could stop the works if he had appreciated something was being done that shouldn't be done?
Correct.
So if he had appreciated, your submission, as I understand it, is that if he had appreciated that this first barrier had been removed before lunch, it's something that he could have stopped the works.
He could have communicated it to whoever.
Irrespective of any role as to site authority.
Yes, ma'am. Houston Majad Singh was the applicant on the permit to work. He was a Counsel employee working for Paria, and he admitted in cross-examination that he was representing Paria. Mr. Majad Singh's evidence was that he did not have any specialist knowledge about the job LMCS was doing. He filled out Section A of the permit to work based on information which he was given by Mr. Rampasad Singh. He stated that his function was to ensure that the form was completed and any documents to be attached were attached. In cross-examination, I have placed a reference. Mr. Majad Singh's evidence included that: 1, he had no experience in subsea maintenance works. 2, He first arrived at Berth 6 at about 2 p.m. on the 25th of February. 3, he did not monitor in the morning period, as the first time he arrived was at 2 p.m. 4, he was not present at the toolbox meeting and signed the toolbox form when he arrived at Berth 6.
Yes.
It is clear, therefore, that Mr. Majad Singh did not have the necessary experience or competence to supervise the execution of job by LMCS as required by Paria's permit to work procedure.
Well, he didn't supervise it at all in the
At
morning.
all.
And certainly until he got there at 2 o'clock, there couldn't have been any supervising by him because he wasn't there.
So in effect, Paria's obligations to supervision was not fulfilled.
I mean, whatever the period of that supervision, whether it's every 20 minutes, every hour, or as one witness put it, every 4 hours, I mean, the truth of the matter is he wasn't there at all in the whole of that morning. And the first time he arrived was at 2 o'clock.
Yes, Mr. Chairman.
The only person who was there was poor old Kirk Scott.
Good, Scott.
Or Scott Kirk, I'm not sure which way around it is. Thank you. All right, thank you.
So we have submitted, he also failed in his duty as stated in the permit to work procedure at pages 28 and 29 to ensure that pre-start meetings were conducted with the crew to discuss the job and to ensure that all personnel read and understood the JHA and assessment. Mr. Budram's evidence was that the work plan was discussed at the toolbox meeting and that it included the removal of the plugs. If this is correct, had Mr. Majad Singh been present at the toolbox meeting, he would have been able to assert Paria's position, which is that the removal of the plug was not part of the work plan for that day, and the plugs were required to be in place during the execution of the works. Further, he also failed in his duty to continually or periodically monitor the works. In fact, he did not monitor the works at all. He only arrived at the site at 2 p.m. The mechanical plug had removed prior to the lunchtime. The applicant, which in this case is Paria, must have, according to the permit to work rules, the necessary competence to execute the job or to supervise the execution of the job. So if Paria is putting someone else, well, someone to do it on its behalf, the person must have the competence, shall be knowledgeable of the hazards associated with the job and the necessary control for these hazards. He shall be responsible for the job and the safety of the people who work for the job. It is also required Paria to continually monitor the job to ensure that it's performed in a safe manner as prescribed in the certificates and JHA assessment, and to stop the work if there are changes, etc. LMCS documents.
Just before we move on, one of the witnesses, I can't remember exactly who it was now, had suggested that that it was wrong for them to have identified the applicant as being someone that they employed. Who was it? Mushtaq Mohammed, yes, thank you. When I think either myself or you were asking questions, he conceded that on reflection would have been sensible for the applicant to have been LMCS rather than somebody that they themselves employed, which seemed on the face of it to illustrate a lack of understanding perhaps of the role of the applicant. Be that as it may, would you say it was open to Paria to have contracted out of that particular element of the permit to work procedure?
No, Mr. Chairman. It would seem to me that from the permit to work rules, there must be a permit to work in respect of works, especially works which of a certain kind. And the applicant, we got an evidence, when evidence was being given, that Paria is normally the applicant.
Yes.
And we had no evidence in this case, no evidence from Paria that the contractor ought to have been the applicant. And it would seem to me that when you look at the contents of the rule and the procedures in the permit to work procedure, Paria could not contract out of that. But if Counsel employed by Paria, working at Paria, is for all practical purposes representing Paria,
Yes.
that is no defense to the fact.
No, I wasn't suggesting that. What I was
responsibility.
wondering was, in the light of what Mr. Mushtaq Mohammed had said, was whether or not it was impossible for LMCS to have been the applicant. You say no.
No.
Right. Secondly, then, it would have been possible for them to have employed someone else. As it happens on this occasion, they were employing someone from Kenson, but they could have employed someone
An
who
expert.
did have those skills.
Yes.
There may have been someone at Kenson, for all I know, who has those skills,
Yeah.
but the fact is the person that they did use didn't have the skills that you say they should have had.
Yeah.
Right. So, and it would have been open to Paria to have employed somebody else in that role.
Oh, yes. Oh, yes. Someone with the necessary skills.
With the necessary skills.
In order to perform the functions of supervision.
Yes.
And Mr. Chairman, remember, Paria being the applicant is consistent with the common law non-delegable duty I talked about.
Yes. All right.
The next area that as part of my submission, is to consider under the heading LMCS documents.
Right.
It is undisputed that the method statements, risk assessment, job hazard analysis, and emergency response plan for these works, which were submitted by LMCS to Paria, Paria reviewed them and accepted them and acted upon them. And I have given the references of the documents, and I would not take up time with that because I think we all know what the documents are.
Well, I think it's worth saying, isn't it? It includes the method statement, the risk assessments themselves, the emergency response plans, further risk assessment in relation to the line clearing.
The GHA for phase 1 air blowing, the method statement in phase 2, the GHA for phase 2 line clearing, the method statement to install the subsea flange, and the GHA to install the subsea flange.
Yes. So a significant number of documents anyway submitted by LMCS for review by Paria.
And Paria accepted it. I mean, and there's no defense for Paria to say we didn't have the competence to do it. If they didn't have the competence to do it, Paria had a duty, both under the rules and under the common law duty, to get an expert. It is not disputed that a potential delta P hazard was not identified in any of the documents submitted by LMCS to Paria and which were accepted by Paria. The LMCS documents were reviewed and accepted by Paria's multi-departmental team comprising personnel from the HSE Maintenance and Operations Department. Paria's evidence is that the purpose of the review was to ensure that LMCS understood what it was contracted to do, that it identified the safety risk associated with the job, and that it had developed a plan to manage those risks. I must confess, this has always concerned me. If a company does not have the competence to do the works or to assess the works, how could you accept these documents without getting an expert to review them on your behalf?
Well, I suppose the parallel that's been drawn is that, if I think Mr. Peterson says, if you employ a painter to come and paint your house and he starts in the first bedroom upstairs and he submits a plan for what he's going to do, you may have not the first idea about painting, no idea about the mixtures that need to be made and so on. You're only interested in the color perhaps and that the work is done, and that your expertise beyond that is limited. And if a person goes up a ladder and falls off, how can that be your responsibility?
But Mr. Chairman, that is the point. This was not a contract like that. This was not a painting contract. This was not a contract like that. This was a contract which, under the permit to work procedure, imposed an obligation for Paria to control the works and control how it was to be done. And under the common law, this was a contract which was for inherently dangerous.
Well, I was going to ask you that. Because does it make a difference that the place where the contract is to be executed is itself a hazardous environment?
Well, it adds to it, Mr. Chairman. It adds to it. So this is a contract, inherently dangerous work, and at a place where the place itself is in a hazardous environment.
Yes, I mean, when we went there, we weren't allowed to move around without putting on a whole lot of equipment, in particular shoes and gloves and hats and everything. Yes.
I was not fortunate to be in that.
No. When I said we, I was looking at
out of it.
This is all right. Okay. You avoided that particular one. Yeah, not just you, Mr. Peterson did too, I noticed.
We share the same concern, my lord.
All right. Yes. Well, thank you.
Yeah. Further, Paria's evidence is that because the works which were to be executed by LMCS were highly specialized in nature and were not of a kind which Paria had the competence or experience to execute, Paria necessarily relied on the specialist expertise of contractors, such as LMCS, to identify the relevant safety risks. Well, this is probably, on hindsight, this ought not to have been done at all. It couldn't be. Notwithstanding that Paria admitted that it did not have the competence or experience to execute the works, it held itself out as competent to review and accept the LMCS documents. Paria therefore did not do a genuine review of the LMCS documents, and Paria, on its own admission, relied exclusively on the specialist expertise of LMCS to identify the safety risks.
And if they get it wrong, so Paria got it wrong.
Correct.
And there's no doubt they did get it wrong.
They did get it wrong. LMCS got it totally wrong.
Yes.
And
Right.
since Paria did not have the expertise, it rubber stamped
The error.
the error.
Yeah.
Paria did not take the steps to have a client representative engineer expert to advise it in reviewing the LMCS documents before acceptance. Paria is in breach of the PTW rules and also in breach of the principle of the common law referred to above. It would appear that if Paria had taken the steps in the 2020 contract to have a project engineer, it may not have got it wrong, because the project engineer...
Well, they all came out alive in that project.
Yeah. The above evidence must be considered in the context of the evidence of the expert, Mr. Zai Khan of Incotech, in which he stated that the root cause of this accident was the failure by both Paria and LMCS to recognize that a latent hazardous differential pressure condition, delta P, would have been created by the methodology used in the execution of the works, with particular reference to the removal of fuel oil from Sealine 36. He further stated that if this hazard was recognized, then simple mitigation steps and a change in the methodology of the works could have been instituted to eliminate this hazard. In our submission, the failure by LMCS and Paria to identify a latent delta P hazard had a ripple effect throughout the project. As a result, the risk assessment and job hazard analysis did not identify control measures to reduce the risk of such a hazard occurring. And as a result, no control measures were in place. There was no adequate emergency response plan to the accident of a delta P event when it occurred. Thirdly, LMCS and Paria employees who relied on the assessments of LMCS and Paria were unaware of the risks and the control measures for those risks. There was therefore a breach of duty of care by both Paria and LMCS.
Right.
I will now go to the line clearing, which I think is one of the important aspects in this case, in this inquiry.
Yes.
We all know, according to the final Incotec report at paragraph 3.1, that the removal of the contents with respect to the quantity and method in line between Berth 5 and 6 was the underlying factor that led to this accident. The removal created a gaseous void in the riser and sea line, setting up a latent differential pressure condition between the habitat and a gaseous void in the sea line when the mechanical seal and the inflatable plug were installed and the habitat was pressurized. End of quote. The line clearing process began on the 18th of January 2022 and was completed around the 3rd of February 2022. According to Jonathan Ramdan, Paria's operations team supervisors, LMCS undertook to conduct the line draining in accordance with Paria's work instruction, effective 5th January 2022. The Paria work instructions, I put the reference, this is a step-by-step instruction for the clearing of sea line between berths 5 and 6, developed by Paria's operation department. It was revised by Paria's Visham Harichan and approved by Paria's Jason Beckers and authorized by Paria's Colin Piper. Mr. Ramdan stated that the purpose of the document was to oversee the draining process and that the operations department of Paria had control over the process. It is to be noted that there are also method statements produced by LMCS for both phases 1 and 2. On page 1038, it is stated on the work instruction that the operator at Paria was to be assigned for monitoring and emergency response. Mr. Ramdan, in cross-examination, also confirmed that Paria officials were witnessing, present, and overseeing the draining process. And I put the reference to 11. Remember that Mr. Ramdan is Paria. Also, Section 8 of the scope of works required the contractor to follow not only the permit to work procedure, but also standard work instruction. So these were work instructions which the contractor had to follow.
Is that what we have at page 1033?
Yes.
What's been described as the internal document for Paria's staff, but which found itself into the hands of LMCS.
Yes, and the scope of works require the contractor to follow work instructions of Paria. Therefore, LMCS would have had a contractual obligation to follow Paria's work instruction. This work instruction was emailed by Paria maintenance planner, Mr. Terence Rampasad Singh, to LMCS on the 10th of January 2022. And it was attached to the work instruction.
To the email. That work instruction was attached to the email. I think
the work instruction was attached to the email.
I think this is something I asked Mr. Peterson yesterday. I mean, this wasn't done inadvertently.
It was done intentionally.
You know how sometimes you can have an attachment to an email which you don't really intend to be passing on. But in this case, it was deliberate.
In my respectful submission, the reasonable inference to be drawn, it was intentional.
Yes. And it is, as you say, literally a step-by-step instruction of exactly how it's to be achieved, isn't it? And in which order each step is to take place.
And then the scope of works at paragraph 4.5 provides that Paria's responsibility included provided personnel to oversee isolation, de-isolation, depressurization, pressurization, and draining / filling product from lines at berth 5 and berth 6.
This is one of the few things that they've retained for their own
Yes,
responsibility
yes, Mr. Chair.
in that very large document. Yes. But it includes this. And on that occasion, there is no ambiguity. It says oversee.
Oversee. Mr. Terence Rampasad Singh of Paria, who had the responsibility of overseeing the execution of the project, stated that this meant that operations would have identified all of the points that need to be isolated, line up the clamps and the valves for the product to go in. He further stated that the contractor would be responsible for draining the product to the required height, and the maintenance department would provide all the permits and all the mechanical support that is required, and the process would be overseen by Paria through its operation department. That is his evidence, and I put the reference in the
Yes. I have to say, I'm still struggling to understand precisely why it was felt necessary to move from pumping to blowing. And I've read something in the papers that one of the suggestions was that there was a danger that water would ingress into the pipe at berth 5 when seeking to draw the fluid from the pipe, and that might have been one of the reasons why they moved away from sucking to blowing, as I put it. But I have to say, I have struggled a little with the idea, bearing in mind you're only taking a relatively small amount out of it altogether.
Yes,
and if there was a problem at one end because it was too low and there was a danger of water ingressing into the pipe, do it at the other end. Because you've got a pipe.
That's my point.
If you're sucking it from that end, it will eventually, as was demonstrated,
It's basically a U.
Yes,
It's a U.
it will
So
equalize
if you couldn't do it at one end, do it at the other end.
Yeah, I have to say, I have struggled with this idea that it was felt necessary to move from one to the other. Whose idea was it to move from one to the other?
It seemed as though it was a joint decision.
Between LMCS and Paria.
And both of them thought that by doing it, that the method, and as submitted to, that they would have achieved the result. They obviously genuinely thought that.
No, I don't suppose I did it deliberately. No, that's never the issue in this. No one's suggesting any of this was deliberate. It's a question of whether it was negligent at all. Yeah.
But it would seem to anyone that even if there was an error, why it was not detected when all this oil was being... that is a difficulty in this case, in this inquiry. So it was the evidence of both LMCS and Paria that the intention was never to drain the entire underwater pipeline between berths 5 and 6, but rather to remove only sufficient content to achieve a 30 feet haulage at berth 6, to install the plugs in order for the works to be carried out. Mr. Kazim Ali Sr., in his supplemental witness statement at paragraphs 31 and 32, described phase 1 and phase 2 line clearing process by way of air blowing. This was a change from the original method statement, which proposed the use of an air pump from the line clearing exercise. The use of the air pump would have involved introducing an air pump at an open riser at berth number 6. However, this method was changed to air blowing after LMCS was awarded a contract following discussions at a kickoff meeting around June 2021, where LMCS and Paria looked at the job in more detail.
I mean, is there ever a justification for pumping air into a pipe unless you are genuinely looking to clear it completely? I simply don't know the answer to that.
Even someone who is a non-expert can think that you're going to use the air to blow from one end to the other end. What is the purpose of doing that? But to clear the line.
Yeah, to clear the line. I can understand if, for example, it was felt necessary to, say, wash the pipe in some way, that you would want to completely clear it of all fluid and then pump in, no doubt, some sort of cleaning substance to remove all the gunk that is acquired over the years, and then having done so, you flush it out and then you refill it with fuel. I think if you're working on a line, well, it does seem extraordinary that anyone would have thought that pumping air into the pipe was a good idea. And we're dealing here with two highly experienced professional companies, LMCS with many years experience and Paria with many years experience. Yeah. All right. Thank you.
Mr. Kazim Ali Sr. stated that they decided that the use of an air pump was not practical.
That's the sucking.
Sorry?
That's sucking. The way I put
Yeah,
it, forgive me for using non-technical expressions,
Yeah.
but it helps me to understand what it means.
Yeah.
So the air pump to suck out the fluid rather than pushing it out. Yeah.
And he said because they would have had to remove the flange from the top of the riser in order to get the pump in, and this risked water entering the riser and was possibly an environmental hazard concern. Further, the top of the riser would have had to be open for a prolonged period of time if an air pump was used and if water entered. This would have caused the oil in the riser to rise and escape from the riser into the sea, causing pollution. But
I don't really understand it. How would it have taken a long period of time for the lid to be open, as it were? You're only taking a few barrels out. I mean, this is a company that must pump tens of thousands of barrels of oil
and those
on a
barrels
daily
could have been
basis.
taken out, as you said, in a bucket.
Yeah, I know I've used that expression, but I mean, realistically, we're talking about, 50, 60 barrels of oil. A barrel's only 42 gallons. Surely this is something that ought to have been done within an hour. Call it 2. How does it need to be open for a prolonged period of time?
10 days.
I mean, anyway.
It is to be noted, however, that the evidence of Paria with respect to its understanding that the line carrying exercise was only to achieve a sufficient haulage to install the plugs is inconsistent with the plain language of the following contemporaneous documents. The scope of works at page 564, CB3, paragraph 315, where it stated, properly coordinated works with Paria operations, maintenance, and HSE personnel to perform the following activities, including but not limited to isolation, de-isolation, depressurization, pressurization, and draining.
The point you made before, one of the features that they retain for themselves, that is Paria, as incumbent upon them, is the oversight of draining. Yes.
And then the addendum, which made it clear that the contractor was responsible for the safe removal of hydrocarbon contents from the line to ensure that the line is clear and dry. I mean, those are clear, unambiguous words.
Well, yes, but even if one was charitable, it's certainly at best ambiguous, isn't it? At best.
Yes.
And given the seriousness with which this kind of work ought to be taken, there should be no room for ambiguity at all.
At all.
No, none of the personnel, be them LMCS or Paria, working on this particular project should have been in the slightest possible doubt that there was only to be removed a certain limited amount of fuel or substance from the line. And to say, as it does, in a specific query raised by a contractor, not necessarily LMCS, but a contractor, to Paria, the company engaging them, that the line is to be clear and dry, does leave a considerable gap between that which I would have thought ought to have been made paramount and clear, rather than, as I say, at best ambiguous. Yes, thank you.
Much obliged, Mr. Chairman. And Paria work instructions refers to the scope as being clearing of number 36 SL section between verse 5 and 6. Clearing. the permit to work at page 1074, which states in section B, line drained.
I mean, this, as you know, has troubled me,
Yes.
and I know Mr. Wilson, for some considerable time. As I say, at best ambiguous, but combined, pretty clear that the instruction seems to be the complete removal of the fluid in the line. Anybody who might not have been privy to the negotiations and what was ideally attempted to be achieved by Mr. Kazim Ali and or the contractor's employer at Paria would be forgiven for thinking that that was exactly what it was that they were trying to do. And therefore, when hundreds and hundreds of barrels were being removed from the line, nobody would have been alerted, would they? Because they wouldn't have been, if they had known this language, they wouldn't have thought anything of it.
No.
To say it's one of the most clear and obvious flaws in the process that was being done. I mean, given the volume of material that we've looked at, the words of every particular clause, you would have thought at least somewhere it would have been absolutely clear. We only need a small ullage, therefore no more than. And I think there's one document where it was speculated that.
Well, if I may offer, it could be simple: do not drain more than so and so.
Yes. Anyway, yes, thank you for that.
But to crown it all, in Paria's daily work reports compiled by Paria personnel, which are referred to below, these documents record that Paria was aware that more than 1,252 barrels of oil was received in its tank farm and also in sub-barges. This, as we shall demonstrate, is more consistent with a line being drained than an intention to partially drain to achieve 30 feet ullage. In the fact that the daily work report showed that Paria wanted the line to be drained, and it participated in the draining process as it was monitoring the draining of the line. In order for the line draining process at Paria's compound to be done, Paria's resources and facilities, including its workers, were used in that process, and it is clear from the daily work reports that Paria kept a record of the draining of the oil.
I noted from that, when you were dealing with it in the evidence, that there were days when they were draining, and there was no record of how much was being drained. But it would appear for whole days, or at least substantial parts of days, there was draining taking place,
but no record,
without recording the amount that had been drained. So when you describe the 1,252 barrels that was actually recorded, it is on any view in excess of that.
1,252 plus.
Bearing in mind that on some of those days, as I say, they were draining for much of the day.
Yeah.
And we've made it clear, I think, during the course of the evidence that we've heard, that something in the order of 50, 60, 70 barrels or so ought to have done it. So we're not talking about some marginal difference here.
A major difference.
Thank you.
Much obliged, Chairman. I will now go to the total content of the topside piping. The evidence showed that...
Do you want to, I was going to suggest that if you finish this part of it, and
yes,
then we might take a short break.
Yes, thank you very much. The evidence showed that Mr. Kazim Ali Sr. believed that 300 barrels had to be removed from the topside piping to drain the topside piping. With respect to the underwater piping, Mr. Ali Sr.'s evidence was that 60 barrels had to be removed to achieve a 30 feet ullage in the riser at Berth 6. Based on that evidence, therefore, no more than 360 barrels ought to have been removed during the entire line clearing exercise. That is 60 barrels from the underwater riser at Berth 6 and 3 barrels from the topside piping. And if I can just follow just the next part.
Yes, I mean, that was using his rule of thumb,
Yeah.
1 barrel per foot, wasn't it? Yes.
Yeah. However, Paria produced contemporaneous daily work reports created by its maintenance technicians, which shows 960 barrels were removed during phase 1 and 336 barrels were removed during phase 2. And that is how I get the total of 1252. Those daily work reports, according to the evidence of Mr. Ramprasad Singh, were emailed to him on a daily basis.
Right.
They were copied to Mr. Manmohan Balkaran, Assistant Planning, and where required, operations.
So it's not as though they were living in sublime ignorance of it.
Paria, in the bosom of Paria, it knew. The imputed knowledge was that it knew the line was being drained in excess of what was intended. And
just
LMCS knew that too.
Right. And just to take the figures you were dealing with earlier, that 916 barrels were removed under phase 1 and 336 under phase 2. Even if, in some odd way, phase 1 did not have anything whatever to do with the subsea line and was to do with top line pipes or whatever it might have been, didn't involve that, it still left 336 barrels plus, I think, one day of blowing without recording the amount.
Yeah.
So you had, on any view, even if you were to take that lesser figure for phase 2, it was still hundreds of barrels more on the face of it than it should have been.
Should have been. Correct, Mr. Chairman.
Yes, is that a useful moment to
Yes,
break off for a short
Mr.
break?
Chairman.
Well, let's do that then. Let's take, shall we resume at 10 minutes to 11, please? 10 to 11. Thank you.
How many minutes is that? How many minutes?
Yes. I
Thank you.
feel the final hurdle approaching.
Yes, yes, Chairman, I think everyone in this room is looking forward for this evening so that we wouldn't have to be here on Monday morning.
Oh, that sounds a little disappointing. I thought you were all looking forward to it.
No, that is not because that we do not want to be here, to be in your company and the company of Mr. Wilson.
That's a poor recovery.
It is just that there are other things to be done, and,
Of course.
and nothing else could have been done because of this.
No, I, for my part, I'm delighted that we have some comments to make a little later, but delighted that we've managed to maintain the timetable that you expressed right at the outset. Yes. Right.
Thank you, Mayor. Thank you, Mr. Chairman. Mr. Chairman, I want to draw the Commissioner's attention to a letter in the record from OSHA
Right.
to Mr. Mustaq Mohammed. It's a letter dated the 20th of July, 2022.
It's in the bundle, I think.
Yes,
isn't
it's
it?
a
There's the one,
pages 2905 and 2908 in the electronic bundle submissions. It was signed by Mr. Mustaq Mohammed to OSHA, in which OSHA asks certain questions about the volume of the oil removed. And if you look at page...
So, and you, as you say, this is a letter dated the 20th of July.
Yes,
Yes.
20th of July, 2022.
Right, we see it on the screen now.
Yes. And it's at page, and if you look at page 2906,
Yes.
it headed clarification of whether an air-driven pump or an air compressor was used to remove hydrocarbon from Sealine 36 between berths 5 and 6 prior to the installation of the subsea slip-on flange. Response: Paria confirms that an air compressor provided by LMCS Limited was used to remove hydrocarbon from Sealine 36 between berths 5 and 6 prior to the installation of the subsea slip-on flange 30 inches. And then there was another question.
So the highlighted part is the query from OSHA.
Yes.
And then underneath the response is
The
from
response.
Paria.
Right.
I got you.
And then you go to 4, the question, response of hydrocarbon removed from Sealine 36 between berths 5 and 6 prior to the installation of the subsea slip-on flange 30-inch diameter as per method statement. Response: given the configuration of the system, it is impossible to segregate and measure the displaced volume. So what this letter is saying, that it was impossible to measure, although from the daily reports, it showed that there could have been some measurement. And there were measurements. And then the next question, the volume of the hydrocarbon removed from the Sealine 36 between berth 5 and 6 after the accident. Response: the volume of hydrocarbon removed is estimated at 125 barrels. The quantity is based on the estimated spilled hydrocarbon, 6 barrels, and the recorded volumes of hydrocarbons recovered in the Sea Manatee, 119.8 barrels.
Sea Manatee was a slot barge, I think, or
Yes,
some sort of
yeah.
barge, was it not?
That's what I understand.
Yes. So they were able to tell the amount of hydrocarbon
In the
that
underwater
came
pipe.
out of the pipe after
Yeah,
the incident happened. In other words, when they were pumping in order to recover the bodies. And they described that as about 125 barrels. But they were unable, at the time that this document was produced, signed by Mr. Mustaq Mohammed on the 20th of July, to tell OSHA how much had been taken out of the pipe before the accident happened.
yeah.
Well, that's not true, is it?
No.
I mean, they did know.
Yeah, they did.
I mean, those daily report records were contemporaneous, were they not?
And they were dated when? From when?
June,
Yeah, but, yeah, And I'm reminded that those records were compiled contemporaneously in January and February of 2022.
As and when it happened.
As and when it happened.
And so to say, as he does to OSHA's inquiry back in July of last year, given the configuration of the system, it is impossible to segregate and measure the displaced volume. That's simply not the case, is it?
No.
Or even if you were unable to give an exact figure, he was certainly in a position, was he not, to have given the figures that you've given us before we had the break.
And this
1,252 barrels.
And this is a letter signed by the head of Paria.
Yes. It's perhaps a pity we didn't put this to Mr. Mohammed when he was here.
Yeah.
Because it's something that perhaps he ought to have explained. What I'm going to do is this. This is obviously quite a serious matter. I think that the sensible thing would be to allow Mr. Mushtaq Mohammed, to address this.
Yes.
So I'm going to ask Mr. Peterson, obviously it's of some importance, this, and there may be a perfectly good explanation. So can I ask that you invite Mr. Mushtaq Mohammed to have a look at the letter that he wrote? I mean, it's been part of the bundle from the start to finish. So it's not as though it's only something that's just emerged. It's perhaps, as I say, a little lamentable that he wasn't asked about it when he gave evidence. But no loss. What we can do is perhaps you'll be good enough to provide him with a copy of this and ask him if he would be good enough to explain what he meant by it in paragraphs 4 and 5, if he's able, and we will take that into account.
I will do that, sir, but I could observe for the time being that the focus between the exchange between my learned friend and the commission is only focused and isolated on measurement as opposed to the inability to desegregate or deaggregate, I think he said, desegregate the system.
No.
So the quantity,
if that's his explanation.
the 1,200 barrels dealing with measurement, but does not recognize the connectivity and the interplay of the system. But Mr. Mohammed, I guess, will better explain it.
Well,
but I make that observation for the time being.
I'm grateful for that observation. Of course, as I've said, there may be a perfectly good explanation as to why he gave that answer. On its face, doesn't seem to be entirely accurate, to put it neutrally. And so I would welcome any contribution he might wish to make in relation to that. And I shall ensure that that contribution is put up on the website once we receive it. And anybody who wants to make a comment about it will be free to do so, as I say, and we will certainly take it into account, all right? Sure. But thank you for drawing that to our attention.
And I do apologize that it was not brought before, but in preparing the submissions, looking at everything, you know, and there are so many documents. Yeah.
I am not going to hold anybody responsible. It's equally my responsibility. These are documents that have been as part of the bundle for a long time now. We've managed tens of thousands of pages one way or the other, and that there was an oversight of this. All of us overlooked it. Mr. Peterson's team, your team, me, and everyone else. So, but we clearly got to give him an opportunity to address this.
Sure.
And I'll invite him to do so. Thank you very much for bringing it to our attention.
I now come to some of the evidence Mr. Zaid Khan gave after he did the presentation, and some of the evidence as it relates to the line clearing. Mr. Zaid Khan, in his Incotec report in his letter dated the 6th of January 2022, stated that out of the 916 barrels removed during phase 1, he estimated that approximately 200 barrels were drained from the topside. This is based on his personal knowledge of the capacity of the topside piping, and therefore that 777 barrels were removed from the underwater sea line during phase 1. In phase 2, he states that at least 336 barrels were removed from the underwater sea line. Therefore, in his opinion, a total of 1,052 of the 2,000 barrels would have been removed from the underwater line. These figures do not take into account where air blowing occurred on occasions, and the quantities of the fuel oil removed were not recorded.
Right.
There was no taken into consideration of the quantity of the oil being removed. The evidence shows that even though Paria had availability the daily records of the fuel oil being removed, those figures did not form part of any consideration by LMCS or Paria to ensure that only the target amount was removed from the riser at Berth 6 to achieve the 30-foot haulage. LMCS did not measure the quantity of fuel oil which was removed, but was measuring the haulage. It would appear that Paria also depended on the measuring of the haulage rather than considering the actual quantity of fuel oil which existed and what had been removed. In Jonathan Ramdan's evidence, and I have the reference there, he stated that he couldn't say the quantity which was removed. He stated that operations was overseeing the draining process by the contractor, LMCS, and that LMCS was doing their haulaging to determine if the right amount of oil was removed. Then Visham Harichan, referenced there, stated that he was of the impression that the haulage was actually giving the amount in the line. Colin Piper, referenced there, stated that the dip on the line is the measurement that the contractor was going to. Visham Harichan also stated in cross-examination that he could not say how much oil was drained or even how much had to be drained. In fact, Mr. Harichan was surprised by the actual amount of line content which was drained. And the question to him was, so having become aware of that now, would you not agree that the unlimited draining of the line, the underwater line between Berth 5 and 6, should have been closely monitored if it had to be drained? Yes, and I thought it was closely monitored. And then the question here, by whom? And his answer was the contractor and the maintenance department, which is the maintenance department of Paria. However, Mr. Terence Rampersad Singh of Paria Maintenance Department, who was in charge of overseeing the execution of the project, stated that he never worked out how many feet of the content in the riser was equivalent to the terms in barrels, in terms of barrels. Mr. Colin Piper, Terminal Operations Manager, agreed that he had the overall responsibility of ensuring that Paria instruction procedure was established by reviewing and approving the work instruction and ensuring that the offshore team lead understood the requirements of the work instruction. Mr. Piper agreed that the Paria work instruction was a step-by-step process which was sequential for the line clearing process. However, notwithstanding the evidence of Jonathan Ramdan that the line clearing was undertaken by LMCS pursuant to Paria work instructions, Mr. Piper stated that the work instruction did not go to LMCS and is solely an internal instruction for Paria operators. However, this is inconsistent with not only Mr. Ramdan's evidence, but also with the contemporaneous documentary evidence of the email from Mr. Terence Rampersad Singh, copied to Mr. Manmohan Balkaran and sent to LMCS on the 10th of January 2022. In that email, Mr. Rampersad Singh attaches the work instruction and states, please see attached sign draining procedure. Let us meet tomorrow at 10 a.m. to discuss draining schedules. I want to start as early as possible this week. Bearing in mind the cruise ship loading is on the 14th, I will discuss with ops now to firm up on any other issues. End of quote. According to 5.3 of the permit to work procedure, Paria as the site authority was directly responsible for the site facility and is responsible for ensuring that conditions required for the safe conduct of the job are maintained. Paria, pursuant to this duty and also in monitoring the works, should have been able to identify from its record that more fuel oil than was required was being drained from the line. LMCS also ought to have known that more fuel oil than was required was being drained from the line.
The sheer time that it took might have indicated that, mightn't it? I mean, bearing in mind LMCS, it is their case, and indeed Paria's, that all they wanted to do was to achieve a 30-foot ullage on either side. The mere fact that this seemingly took days of pumping must have told them surely that they were taking out more than the 30-foot ullage that they required on either side. As I've indicated before, you could do it with a bucket. You know, it does seem somewhat extraordinary that nobody at LMCS was saying, well, hang on, how much are we actually taking out if this is taking day upon day upon day?
And one would have thought that LMCS, who was actually operating, ought to have realized that more than that was
Yes. I mean, it is the evidence of Kazimali that he that's all he wanted. He only wanted this 30-foot ullage. I mean, someone of his experience must have appreciated, surely, as the days ticked by, that they must be taking out more than the ullage was required. And it's all very well saying, well, I kept putting a dipstick down to see where it was. But the truth was that why didn't he query it? This is the obvious question, I suppose. But he didn't, did he?
He didn't.
No. Thank you.
I now refer to Mr. Zaid Khan evidence in which he showed, from his evidence, the measuring of the ullage did not detect the gaseous void.
Right, would you just give me one moment? I just want to make a note against that. Thank you.
Mr. Zaid Khan said that the removal of the line, and this is what he said in evidence before this commission, that the removal of the line contents to 35 feet below sea level in the riser. If that had been undertaken, no gaseous void would have been formed on the installation of the plugs.
That's his video number 4.
Yes. Further, at paragraph 313 on page 1397, he stated that the method of air blowing from berth 5 to 6 would have resulted in the removal of the way in excess of the optimum quantity of oil from the line, thus creating a significant continuous gaseous void between berth 5 and 6. His evidence given in cross-examination on the 10th of January also established that, 1, the method of removal of line content would have given the impression that a target of a 30-feet ullage was attained in the riser when a dip measurement was taken, but this would not detect the gaseous void in the horizontal part of the line. He also stated that the pipeline sloped at 0.2 degrees. Berth 6 is 4 feet lower than berth 5 end, and berth 6 is deeper than berth 5. The line is sloped, and the initial stages of blowing would have resulted in a lot more liquid flowing out from the line than if it was level. He stated that the riser at berth 5 would be emptied first as pumping was done from berth 5. He also stated that during phase 1, air blowing that a point would have been reached when more air than fuel would have been seen coming from the control valves at berth 6 and onshore where the flow was being monitored and measured. This would have been an indication that a lot of the line content had been removed. He explained that when the compressor was shut down at Berth 5 at the end of phase 1, air will be locked in, and that pressurized air would have supported a column of liquid in Berth 6. Therefore, whoever took the dip measurement at Berth 6 would have wrongly thought there was still liquid to be taken out to achieve a 30 feet haulage. In phase 2, the pipe was pressurized internally and a dip hose used to remove the line contents at Berth 6. However, even when the haulage was achieved, it was a false haulage given the belief that the line was still flooded because nobody looked in Berth 5 to see what was happening.
And that would have been a simple test, wouldn't it? Just have a look what's happening at 5.
Oh, Berth 5.
So if you're looking for a dip test at 6 of that 30-foot ullage, you only had to be at the other end to see what the ullage was there. And if it had completely drained the pipe there, as it would have done from the diagram that I drew on the board, they would have appreciated that something was wrong.
Yes, Mr. Chairman. Then he talked about the carber test. When the carber test at Berth 5 was done on the 25th of February, the pressure was released and it created a vacuum on Berth 6 under the plug, and it accelerated and made the system more dangerous. That was a dangerous vacuum which could have dislodged the plug if it was not holding.
Right, as I understood that evidence, the lid is on at 5 and they're taking fluid out at 6. It open the lid at 5. They then do their carber test. But when they open that lid, any pressure that existed in the process of drawing fluid from 6 would have been released.
Yes.
The consequences are the fluid then does this again. But by now, we've got the plug in at 6. So when the fluid does that till it finds its balance, it has created a vacuum underneath the plug at 6. Lid put back on, preserving the position. As soon as you take the plug out, the vacuum that would have been drawing down on it is activated because you've now loosened it. And so the whole thing, not only have you got the downward pressure from the habitat chamber pressure, gravity, you also now have a vacuum. Treble whammy. Yes.
So it's more aggressive.
Yes. Thank you.
I think that was the word I asked him and he said it.
Yes.
Yes.
That's exactly what he said, more aggressive.
And then he concluded that if the line was filled on both sides to the elbow, the incident would not have occurred. And he demonstrated that on the screen.
Yes.
And there would have been no conditions to establish a flow for a vortex to form. He also stated that whether it was 300 barrels removed or over 1,052 barrels removed, there would have still been a latent delta P hazard. When he did his report, he did not know the extent of the contents removed from the line. He went by the method statement supplied by LMCS, which states 300 barrels would be removed. If 300 barrels were removed, there would have been a gap of 7 or 8 inches of air space along the top of the line. If more was removed, the gaseous void became larger. He stated that 300 barrels was way too much to be removed. He referred to LMCS' original plan, which was to drain the topside piping, take off the elbow, and to remove fluid from Berth 6 by way of an air pump at Berth 6. However, he doesn't know why there was a change. This would have been a safer method of removal. The experts' conclusions, therefore, were that had only enough line content been removed to create a 35 haulage, then a delta P event would not have occurred, sucking the men into the pipe. Further, he concluded that the method utilized of air blowing resulted in more than the target quantity of line content being removed, which gave a false impression when a dip measurement was taken at Berth 6 that the line was full of content. If Paria and LMCS had identified, a possible delta P hazard in the document submitted by LMCS to Paria for review, this delta V event would not have occurred because measures would have been taken to mitigate the risk of a delta P event. This highlights the importance of having professional engineers to monitor, to assess the risk in these kinds of jobs, and also to monitor properly trained persons to monitor this inherently dangerous works.
I mean, the long and the short of it is that if Mr. Khan had been given the facts prior to the work being carried out, that is after the line draining, but prior to the work being carried out, he would have at least identified the potential for a delta P hazard existing.
Yes, Mr. Chairman. And you would have seen Mr. Khan's evidence, and Paria LMCS did not disperse his expertise, and therefore anyone in his category would have been able to give that advice. That is why it seems that jobs like these really need a client, an expert client representative to safeguard the interests of whoever it is, whether it's a contractor.
Well, somebody completely independent from the contractual process in a way, isn't it?
Yeah.
Thank you.
I now go to the post-incident responses by both Paria and LMCS. In examining the evidence of the rescue efforts made by Paria and LMCS after the accident occurred, when these men were sucked into the pipeline, it's important to consider that evidence in the context of the following facts. LMCS documents the emergency response plan, the risk assessment, job hazard analysis were reviewed and accepted by Paria because Paria considered them satisfactory and that they captured and properly identified all credible scenarios, potential risks and hazards. Paria took the position that LMCS adequately specified mitigating, control, and emergency response measures. And I've put the references to Mr. Michael Way's evidence and Mr. Randy Archibald's evidence of Paria. It is also not in dispute that both Paria and LMCS did not identify in those documents the risk of a delta P event.
It's pausing there for a minute. I mean, as part of recommendations that we're considering, the documentation that exists both at Paria and any potential contractor must, on its face, raise at least the prospect of delta P when dealing with anything to do with pipe work. I mean, one has only got to look at the sheer volume of pipes that run around the system that is at Paria, and valves that are being opened and closed, volumes of fuel being moved from one place to another. And when you see that, the idea that anyone could be working on a pipe and not at least give consideration to the existence of differential pressure seems extraordinary.
I agree with the chairman. I agree with you, Chairman.
So whenever works are being carried out on pipe work in the future, someone needs to say, what about delta P? And then you either rule it out, you mitigate it, whatever it is, but at least you've raised it as an issue that needs addressing.
For example, if that was followed in these documents and you had someone who could have identified it, an expert or an engineer or like the previous contract probably, they would have probably said, listen, if you're going to drain that amount of oil, let us check it and see whether by draining that amount of oil with the process, 300 barrels is permissible to be drained.
Well, I mean, the fact of the matter is there were easy ways of testing whether it worked. I mean, one of the most obvious was to open the flange at the other end and put your dipstick down there.
Yes.
Because if the ullage on that side was it should have been more than 4 feet difference. Bearing in mind one end is lower than the other, the maximum difference between the two would have been 4 feet. So if you were looking for 36 on one side, you'd have had 32 or whatever it is on the other. You know, and that would have told you straight away that you've got a full line. Yeah, all right, thank you.
It is also not in dispute that both Paria and LMCS did not identify in those documents the risk of a delta P hazard. Now, Mr. Khan, in the Incotec report at paragraph 2.4, stated that LMCS job safety analysis, method statement, risk assessments, toolbox meetings, Paria's PTW 9320, and its bid evaluation of LMCS proposal all failed to identify this potential differential pressure hazard. So the failure, therefore, of both Paria and LMCS to identify a delta P hazard, in our view from the evidence, caused the accident in which these 5 divers were sucked into the pipeline. Paria and LMCS were therefore jointly responsible for the accident and were therefore jointly responsible to make efforts to rescue the divers.
What do you say to Paria's position that starting with, if you like, the toolbox meeting at least, there is no reference to the removal of the plug, and there was a need to obtain a work permit to remove the plug. The existing work permits never said anything about removing the plugs, and had LMCS workers adhered to that, this would not have happened, even though a delta P had not necessarily been identified. The mere fact that they had no authority to remove those plugs meant that they acted on their own and without authority.
If that was the position, then I would not have expected a method statement to accompany the work permit. The method statement stated the plug to be removed. And if it was Paria's, if Paria intended to take the position that you needed another work permit for that matter, I mean, there should be positive evidence that in matters like this before, another work permit was issued.
Yeah.
But we have no evidence adduced. But what we do have, a permit for the work to be done, signed by the agent of Paria. We have a toolbox meeting in which you had a method statement to remove the plug attached to the work permit.
Yes, but that method statement covered the entirety of the works. It isn't said, is it? I mean, in fairness to Paria, the mere fact that they've attached the method statement, which starts from, you know, moving the barge, if you like, right from the very beginning, right to the very end, when the job is finally complete and the last bolt is tightened up and you're taking the barge back again. It's not envisaged, is it, that method statement covers only the period that the work permit was covering. And the work permit sets out in those, albeit just 3 lines, but it does set out what the jobs are. And their case is, well, look, the removal of those plugs is a serious and significant part of the job. And if they were to be removed, that should have been spelt out in the work permit. It wasn't, and therefore you shouldn't have done it.
Well, that's the point, is that there was no, you had the method statement. So if it was the intention of Paria that you had to have a separate work permit, or it was not to be part of the job, on that work permit, just as they put migration barrier to be used, they could have stated exactly what it means. But to leave it in the ambiguous position, and Paria taking the position of enclosing the method statement, and that is why now you have 2 sets of evidence, One saying that the job was to be done, Paria saying it should not have been done. But this had to be clear and unambiguous if that was Paria's position. These were dangerous works.
Their position is, look, if you start with the work that's being done on the day, you look to the toolbox meeting. The toolbox meeting says nothing about any of the works, actually, but it certainly doesn't say anything about the removal of any of the barriers. Okay? So that's the starting point on that day. Now, I appreciate that we've had evidence from Mr. Boudram to the contrary, but on the face of the documents, that is the position. You look at the work permit, it says the barrier to be used. Not to not be used or to be taken out, but to be used. And there is nothing on that document which suggests that you're allowed to remove the barrier. And so again, just dealing with the documents, leaving aside the oral evidence that we've heard, they say that of itself is powerful evidence to demonstrate that there was never an intention at that stage to remove the barrier. If we were to find that that is the position, then of course LMCS removed it contrary to what appears to be the position on the face of the documents. Now, appreciate we're going to look at the oral evidence as well, but just on the face of the documents, there's nothing to suggest, is there, that they should be removed. Appreciate that we've attached the method statement, but that is a document which covers the entirety of the operation, not just what was to be done on that day.
Mr. Chairman, I take the position that if these are inherently dangerous works and Paria has a control of works process and a system of works, it would seem that it is only reasonable that if you are having a very hazardous area of the job and you're saying that a migration barrier is to be used, it should specify specifically, and bearing in mind in this matter, we do not have any minutes of what happened at the toolbox meeting.
Well, we have a note. We do have a note of what happened at the toolbox meeting.
But we
it
don't
just
have
says nothing about it.
Nothing about it. So if we don't have a system, or Paria did not introduce a system to monitor these works, have a contemporaneous notes.
I'm sorry, is that entirely fair though? I mean, they have a system. It may be flawed and it may be open to some criticism, but a toolbox meeting is there designed to provide a system of safe working immediately before the work is carried out. So whatever might have gone before, this is what we're doing today, boys, right? And girls, if they're involved. This is what we're doing today. That's the job that needs doing. Here are some of the risks associated with the job today, right? You guys, off you go. This is the job, all right? That it seems on its face is not an unreasonable approach to take. They are entitled, are they not, to look at the document, which is after all in LMCS's hands, and say, all right, all they did on that day, on the face of it, now that we look at it, is to describe COVID regulations. What if the weather changes? Don't slip over and hurt your finger or something like that. That's basically, we're dealing with that kind of safety issue. It says nothing about the work at all. And why are they not entitled to say, with all due deference to whatever other evidence they may be, that on its face was a virtually contemporaneous document that makes it clear nothing was to be said about it. And adding to that, not unreasonably, they say, the work permit doesn't have to say, do not remove the work barrier, the line barrier. It's not meant, it doesn't have to indicate, do not take this out of the pipe. It simply has to indicate what jobs they are entitled to. That's there. I hope I don't misrepresent it. I dare say if I was, they would jump up.
That toolbox meeting has to be taken in the context, Mr. Chairman, that it was a process to ensure that what works had to be done were known to LMCS for the works to be done. And that is why the control system provides for Paria's representative to be there and ensure that what was discussed at that meeting was for the works to be done. In this case, that process was flawed. The gentleman wasn't there. So in effect, one has to look at the process for the safe conduct of the works. And the rules provide for that toolbox meeting for the work plan to be discussed at the meeting. And if the work plan has to be discussed at the meeting, Paria's representative had to be there in order to monitor and ensure that it was doing its duty.
I agree with that. I mean, I've made the observation already that there was nobody on that berth first thing in the morning when that, from Paria, when that toolbox meeting was being conducted. I accept that, and that's not in dispute. But they are entitled, aren't they, to say, well, look at the document. The document says nothing about any of the work.
Oh, yes, they're entitled to say that, but in assessing the evidence, we have to look at the whole process before the works were completed. And when you look at the whole process, even if that is in favor of Paria, one has to see what was the safety measures by the rules to prevent this thing from happening. And one of the safety measures is on the morning of the work, when the toolbox meeting was being discussed, Paria's representative had to be there in discussing the work plan. And Paria's representative had to make sure that the work plan was in accordance with what was permitted to be done that day.
Yeah, I mean, their position is that, all right, we didn't have any notion that this was a delta P potential hazard. What we were concerned was that the gases wouldn't go into the chamber and cause a problem for the people working there, which was a legitimate concern. Similarly, we don't want anything to fall into our pipeline,
fair enough,
which we'd have to then fish out.
Yeah.
So in that sense, they had a genuine concern to preserve the welfare, on the one hand, of the people working there, which no doubt was their duty to do, and secondly, to ensure that the integrity of their plant wasn't compromised by things falling inside it.
So that's very important evidence, because as far as Paria was concerned, it was not an accident in which you will have a delta P and the men could be sucked into the pipe.
No.
The plug, as far as they were concerned, should not be moved because of something falling into the pipe.
Yeah, and gas is coming out.
Right?
Yeah.
And that brings to the question the importance of having the process followed. Otherwise, a failure of one of the process can have a ripple effect. And I mean, on the evidence, Mr. Chairman, on the evidence, the failure of the delta P had a ripple effect right through the process.
But what if Mr. Wilson and I were to conclude that on balance, as I regard it as our duty so to do, rather than any other test, that if on balance we were to conclude that there was no discussion about the removal of that plug on that day at the toolbox meeting, what impact does that have on the overall decision?
Well, it means that for that meeting, Paria did not discharge its duty to ensure that the work plan was discussed in accordance with the rules.
You mean the failure by LMCS to discuss the actual work to be done that day because it wasn't being monitored by anybody from Paria? Both bear some responsibility.
It's a joint responsibility.
So if somebody from Paria was there, he would be saying, well, I think you really need to tell them what they're supposed to be doing.
Correct. And that is why it was important for Mr. Majad Singh to be there, and there's no excuse to say he had something else to do.
Yeah, all right. Yes, thank you for that. I think, Mr. Wilson, do you want to ask him about the method statement? All right. Okay. Lovely. Thank you very much for that.
And Ms. Maharaj has pointed out to me that in 5.1, It is stated at the end of
Is
page.
this the method statement?
No, this is the permit to work rules.
The permit to work procedure.
Yes, at page 21, at page 28, the duty of the applicant, Mr. Majad Singh, at the end of the page, ensure that pre-start meetings are conducted with the work crew to discuss the job.
That's paragraph
5.1, and
5.1.
the last bullet point on page 28. And as the site authority at 5.3, page 30, Paria was directly responsible for the site, and it had a duty also to ensure that the job was done in accordance with the approval.
Yes, thank you very much.
Now, in dealing with the rescue, in the context that I am saying that both Paria and LMCS was responsible for not having an emergency response plan on that day, I then referred to the Incotec report, which stated that the best time for the rescue was immediately following Budram's emergence from the pipeline at about 5:30 p.m. and maintained that a rescue was possible. He explained that the risk of a secondary Delta P event was minimal because the system had stabilized and something would have had to trigger a Delta P. And I put I wouldn't read what is stated there because we have heard that in the evidence. Mr. Zaid Khan in his evidence maintained that position in cross-examination and explained why the rescue was possible immediately after Budram's emergence from the pipeline and why a secondary Delta P event would not be triggered by rescue divers. His expert evidence on that was not challenged. In fact, Mr. Piper and the IMT's evidence is that after the accident occurred at 2:45 p.m., conditions in the pipeline were static. At paragraph 120 of his witness statement, Mr. Piper stated that the conditions on either side of the inflatable plug appeared to have stabilized after the occurrence of the event.
Mr. Piper says that, does he?
Yes.
Yep. Thank you.
The evidence disclosed that LMCS devised 3 rescue plans, but none were implemented by Paria because Paria from 6:05 p.m. on Friday, the 25th of February, 2022, prohibited diving into the pipeline for the LMCS divers to attempt a rescue. The evidence has disclosed that Paria did not have any consultation with the LMCS divers to review and assess their plans to rescue the divers from the pipeline. Paria admitted that it did not have the requisite expertise to review the emergency response plan submitted by LMCS at the bid stage of the project. Michael Y. in cross-examination said that Paria did not have the competent diving personnel to assist it with planning and executing the job. Paria did not retain an expert client representative to advise it at that stage in assessing the emergency response plan. The 3 rescue plans which LMCS had, one, the first was just after the accident, and it involved Andrew Farrer entering the pipeline with scuba. And I've put the references where that could be found. He could not do it because Paria did not approve it. The second plan was when Conan Bedo arrived at Berth 6 at about 5:45 p.m. The plan was the first for Conan to enter the habitat, to make an assessment using a rope, while Farah and another person would be tending that rope from the barge. If Conan assessed that he could do a rescue, he would then go back into the habitat with Michael Kurban and Ronald Ramuta. He, Conan, would then enter the pipeline using a rope, and Michael Cowan and Ronald Ramuta would be tending him into the pipeline. Conan would go with scuba equipment feet first and share his air with any of the men he encountered and bring them out of the pipeline, and I put the reference in the proceeding. The third plan was the second plan, which was revised when Conan's brother Conrad Beddoe arrived with commercial equipment at 6:30 p.m. Conan, supported by other experienced divers, could enter the pipeline with commercial diving equipment. The plan was for Conan to go in feet first, and someone would tend the hose. The umbilical was 300 feet long. His intention was to go as far as the umbilical would allow. If Conan came into contact with one of the men, the plan was that he would bring him out via additional half-inch hose connected to the umbilical. The men would use the connection to breathe, and Conan would hold them and bring them back up, and the others in the habitat would assist to take him out. The diver who Conan rescued would be down by his feet, so he would come out first, and then the diver would then be pulled out. The plan was that if Conan entered any obstructions, he would take them out one at a time. He would do this as many times as he could. Catherine Balkisoon was informed by the LMCS divers that they wanted to execute the rescue plans on more than one occasion, and she was also informed that there was commercial air equipment available. The evidence disclosed that Mr. Piper first heard of the accident at 3:10 p.m. and Paria commenced sea searches at 3:10 p.m. The divers were reported missing at about 2:45 p.m. Mr. Piper admitted that as incident commander, it was his responsibility to respond urgently to the emergency. Mr. Piper admitted when probed in cross-examination that at 5:36 p.m., he heard that Mr. Budram emerged from the pipeline. And I've put the quote there. When he found out that Mr. Budram emerged from the pipeline, that it was very important for him and the IMT to take urgent steps to see whether he could have saved human lives. Mr. Piper also said at paragraph 47 of his witness statement that in his mind, this was an urgent and critical situation. Catherine Balkisoon agreed that time was of the essence. Michael Way, in cross-examination, considered that the men might be alive some 13 to 14 hours after Budram emerged. And in his personal time frame, not the IMT, there was no real prospect of the men still being alive after 7 a.m. on Saturday. Mr. Piper, on being questioned, suggested that the timeline for a rescue was 3 to 5 hours after Mr. Budram emerged. He said that the IMT understood that we had to work quickly, but that no attempts were made to calculate the outer limits of the breathable air available to the divers. He said that the ICT had limited information at that time. Later, Mr. Piper said that he was working with an outer limit of 5 hours, which may be midnight at the outside, and agreed with the chairman that a timeline informs you about how to approach any potential rescue. Similarly, Mr. Mustaq Mohammed said that Paria/the IMT did not establish a specific timeline for rescue, but were thinking within 6 to 12 hours for available rescue. Mr. Piper's midnight timeline must be contrasted with Mr. Michael Way's with Mr. Michael Way's 7 a.m. on Saturday, Mr. Mustaq Mohammed 6 to 12 hours, Mr. Randy Archibald 24 hours or 2:30 p.m. on Saturday, and Ms. Balkisoon's time was of the essence. All of Paria's witnesses agreed, however, that there were diminishing returns, so the longer the delay, the greater the likelihood that the divers will not be alive. It follows, therefore, that notwithstanding Paria's evidence that it recognized the urgency of a rescue and for the IMT to take urgent steps to see whether lives could have been saved, the evidence discloses that Paria's IMT failed to act urgently and decisively in that the following. It
Just
conti-
pausing there for a minute. Is it a fair criticism
Well,
is it a fair criticism of me and others that there was no timeline established in the IMT at the outset, and that the first we discover of any kind of reckoning in relation to the time that they considered anybody might still be alive varies widely between the various people at the IMT?
Yeah. And I've itemized here, it continued to search the open waters until 5:30 p.m. on Friday, even though Mr. Piper admitted that he considered the possibility of the men being in the pipeline since 3:20 p.m. when Kazim Ali Sr. told him that the plug was being removed, and I put a reference. Paria knew since between 3:20 p.m. and 3:30 p.m. that LMCS divers were prepared to go into the pipeline to do a rescue. Paria did not take steps to urgently speak to Budram about the conditions of the pipeline, even though Budram was conscious and alert when he emerged at 5:30 p.m. Piper agreed that Budram was not overly injured, and I've put a reference. Piper, in questioning, said that Shane Ramkisoon visited Budram in the hospital and admitted that he did not know what Ramkisoon had asked Budram. In particular, whether he had asked Budram about the conditions in the pipe. I've put a reference. The IMT notes also do not show that the IMT through Ramkisoon asked Budram about the conditions in the pipeline. I've also put in reference. The IMT notes at page 5, 1573 records that at 8:35 p.m., Ramkisoon was dispatched to the hospital by Mr. Piper, and at 8:53 p.m., records that Budram was in a stable condition, but is silent as the conditions, but is silent as to the conditions of the pipeline. Budram, in his evidence when he was rescued, said that everybody was a set of headless chickens and made it clear that he was prepared to tell Paria or LMCS soon as he was rescued about the condition of the pipeline. Question to Mr. Budram when he was questioned. Okay, Mr. Budram, I want to ask you a very important question. If when you were rescued, either by Paria or LMCS wanted to find out from you the condition in the pipe in order to effect a rescue, were you in a position to tell them what the condition of the pipeline was? Answer. When I now come out the pipe, my mind and everything was focused and tuned to everything to save them fellas. If they had debriefed me there and then, they would have get everything that they could get from me, including the condition of the pipe. Yes, man. And his answer was everything I could tell them. So after Budram emerged from the pipeline and stated Faizi is just behind me, Michael Kurban shortly thereafter dived into the pipeline in order to rescue his father. He dived down the vertical and then dived about 10 feet down into the horizontal section of the pipeline. He had to return because he wanted a longer umbilical, and he was prevented thereafter from going back into the pipeline. Mr. Piper knew since about 7:15 p.m. on Friday that there were competent LMCS divers willing to go into the pipeline to do a rescue, but stopped diving at 6:25 p.m. and notified the Coast Guard to stop diving at about 7 p.m. and refused to change those instructions. Paria did not act urgently to obtain information from the diving companies when they arrived, and instead they were told to await further instruction, and I would itemize that later. Paria continued to await a rescue from the Coast Guard up until 1 a.m. on Saturday, even though the IMT knew since around 8 p.m. that the Coast Guard was not equipped, nor did they have the training and competence to dive into the pipeline. Mr. Piper's explanation for stopping the diving into the pipeline at 6:25 p.m. was that he had to assess the conditions in the pipe. He said that he did not want to act instinctively or emotionally. I've put a reference. The IMT had a duty to explore all possible ways to rescue the men in upholding its first principle of the ICS, which was to safeguard human lives, and it had to act to uphold that principle of Paria's safety first system. Mr. Y's description of the performance of the IMT after much consideration was excellent. The question arises, is this opinion supported by the evidence?
Pausing there for a moment. You say that the IMT had a duty to explore all possible ways to rescue the men in upholding the first principle of the ICS, which is to safeguard human lives. Do you mean by that a legal duty or a moral one?
Well, I respectfully submit that it was a legal duty, and I say that for this reason. From my submissions this morning, I have shown that there was a duty of care to be exercised by Paria having regard to the inherently dangerous work, quite apart from the permit to work. I have shown this morning in my submission that both Paria and LMCS ought to have detected the delta P hazard from all the documents before the works were done. That caused no emergency response plan to have been, with the delta P hazard being approved. So Paria shared that responsibility. It's a joint, that failure was a joint failure.
So I get the duty at that stage.
Right.
Yes.
So if as a result of that failure, an accident occurred, which occurred because of the failure to identify that hazard, and there was no emergency response plan in place, my submission is that in law, there's a continuing duty in the circumstances for Paria to take whatever steps that is reasonably necessary to rescue the men.
So in terms of a legal duty, we would have to find that there was a duty of care at the outset. And you say there then that duty of care continues up until and including attempt at least at a rescue.
Attempt.
Right.
I'm sorry, I think that is the word I should use. Attempt to rescue.
If we were not to find that there was a duty, that Paria had a duty of care at the outset, that was all LMCS, there's therefore no continuing duty.
Well, I would submit that based on the permit to work rules, quite apart from the common law duty,
Right.
based on the permit to work rules, there were joint breaches by LMCS of that duty when the emergency response plan did not identify a delta P hazard.
Yeah, but in legal, I just want to understand what your submission is in legal terms. You're suggesting that Paria had a duty of care to at the outset, right? And it follows from that you're saying there was a continuing duty of care that extended to the point of attempting a rescue. And I understand what you're submitting is that they failed in both of those, right? I understand what you're saying. But what I'm asking you, I suppose, is that if we were to find that there was no duty of care breach on the part of Paria to start with, would there be a duty of care, continuing duty of care? There's nothing to continue from, is there? The duty of care.
Well, if the tribunal finds that as a matter of law, there was no duty of care from the beginning.
Or no breach of it.
Yeah, breach. Then I mean, I would think that if Paria is a site authority and you have a situation where men are sucked into a pipeline, and as a site authority where there's a risk of men dying, that and this is in the compound of Paria. This is not outside there in the open.
No, it's on their land, I appreciate.
It's on their land. And LMCS could not have acted on their own to do this rescue. This is not a case where LMC is saying that you should send somebody in to do this rescue. LMCS was saying, this is not sending anyone to do this rescue. This was people offering to risk their lives to do this rescue. And it would seem to me, Mr. Chairman and Commissioner Wilson, it would seem to me that the law would be impotent if in a situation like this, there would not be a duty of care in those circumstances to say that Paria had a duty, because in this case, in the facts of this matter, what has happened is that Paria took the responsibility that is LMCS responsibility. They had to come up with a plan. They had to do it, but Paria took the position. And the facts are they didn't even consult them. They didn't even talk to them to find out what is the plan. They didn't get an expert to assess this plan, to see whether it could be done. And this is not a case where oil was escaping. This is a case where men were in a pipeline. And it is that context I say that even if it is not a continuing duty, or even if it is found that there was no duty of care from the beginning, at the time when the incident occurred, and it's on Paria's property, in the circumstances of this contract, there was an implied duty of care.
But a continuing one, not a separate duty of care that
No.
arises only to rescue.
Well, if it is that there is not an initial duty of care, and the tribunal find that as a matter of law, it cannot find that. Notwithstanding that, I am submitting as a matter of legal principles to the Commission
Right.
that where, according to this contract, Paria is the site authority, Paria was responsible, jointly responsible, LMCS, for this incident to occur, this accident to occur. So in effect, they had joint responsibility for the men being in the pipeline. They were responsible for the crisis, just as LMCS was.
I follow that, but that all comes back to the question, doesn't it, as to whether or not there's a duty of care at the outset. My concern, let me illustrate it like this. I mean, there's we're not concerned here with the morality of it. Neither should we be. We all understand as human beings what our moral obligations are, where they lie. So I want to, for the moment, just to set that to one side and concern myself with the legal principles. There is no obligation in law in this country and in many countries, in fact, the majority of countries, to rescue anybody, is there? If a person is drowning in a pool and all you have to do is to reach out and pull them out of the pool, there is no obligation on you to do so. And a failure to do so is not an offence in crime, neither is it a civil wrong.
I agree
with
that.
It's neither of those things.
I agree with that, Mr.
So a small child is drowning at my feet in a swimming pool, and all I have to do is reach out and pull that child out, and I save their life. If I choose not to do that, there may be considerable moral opprobrium attached to that, but I am not legally liable, am I?
No, you're not liable.
There are countries which make that a liability, but not in this jurisdiction, or in the vast majority of common law jurisdictions.
Yeah.
So if that is the position, that there is no legal obligation to effect a rescue, why does that not apply to Paria's efforts, such as they were?
With respect, and my duty is to advise the Commission as best I can.
Yes.
It is my submission that this is not a case where someone is drowning in a public place and you have a pedestrian walking and he did not attempt a rescue. This is a case where there's a
Well,
contract.
even if it's my swimming pool, I own it. It's on my land.
But
It's a child who came round to visit
Yes,
my friends.
But Mr. Chairman, this is a case in which there's a contract.
Right?
There's a contract. And there's a contract for Paria to, part of the contract, to ensure an emergency response plan was put in place. That plan, that duty was not performed by both LMCS and Paria.
So is it a breach of contract then that they failed to effect a rescue?
Well, it's because of the breach of the contract and what happened, the accident occurred. The duty has arisen as to whether they have a duty of care to do anything.
Right.
So one can have an express contractual duty or an implied contractual duty. And therefore the question is, this is a case in which you have Paria in charge of the compound. Paria could prevent persons trying to save the lives of these people. Paria exercised that right. And therefore, if it is shown that it was grossly reckless or negligent for Paria to do that, then in my respectful submission, they had a duty, because this is saving lives. This is not any other thing.
Do you have any authority for that proposition?
Well, I don't have it with me, but I can supply it to the tribunal to make an argument.
I would certainly like to see such an authority, because it's something which has obviously exercised me as to legal principles, what obligation there was on Paria. We all know there's a moral one, and but I have to obviously consider
I
beyond
agree.
that morality.
I agree with you, Chairman. I agree with you that one has to look and see what are the principles of law, if they can apply. And I will certainly assist the Commission as best I can.
Well, I'd be grateful for any assistance, and I welcome anybody else making any submission, potentially, hopefully in writing rather than anything else, with any authority that deals with it. And I look in particular to Mr. Peterson and Mr. Mutu about that. If there are submissions in that respect, I would like to see what law there is to support such a proposition, because I'm troubled by it.
Much obliged, Chairman.
Thank you very much.
So it is in that context I submitted that if Paria wanted to get information about the conditions in the pipeline to decide whether to authorize a rescue from within the pipeline, Paria could have gotten that information from Budram and from Michael Kurban. Further, the IMT's handwritten note contained an entry at 2:02 a.m. on Saturday, 26th of February, stating no signs of oil. Further, all of the commercial equipment needed for the rescue dive were available to LMCS divers by 7:14 p.m. on Friday. Sitaram's evidence to the Commission is that LMCS had all the necessary equipment for the rescue when the vessel Waterworld arrived at 7:14 p.m. Catherine Balkisoon at paragraph 16 of her witness statement said that between 6 p.m. and 6:30 p.m., Andrew Farrer, LMCS dive supervisor, told her that LMCS divers and their diving equipment, scuba tanks, were coming from Carenage and they wanted an escort. This means that a dive plan was being formulated. Balkisoon also said that she communicated LMCS diving plans to the IMT. Balkisoon agreed that she was not merely a conduit for the IMT. And at paragraph 9 of her witness statement, she said she had to provide on-site logistical and technical assistance and support the search and rescue efforts. Balkisoon was asked whether Andrew Farrer had spoken to her about a rescue plan that LMCS had devised to go into the pipeline. And Balkisoon responded saying that Farrer told her that LMCS had divers and commercial equipment and were willing to do a dive and rescue. Balkithun said that she spoke to Colin Piper about it, and Piper's response was to stand down, and I've put the reference.
Yeah.
Balkithun in questioning said that Farah asked her more than once about a rescue and that her response was the same. Both Catherine Balkithun and Mustaq Mohammed stated in their cross-examination that it was not possible to have an emergency plan to rescue someone after a Delta P event. I submit that this cannot be correct.
Yes.
Balkithun said that the IMT did not have a written plan to deal with the Delta P, so that when the IMT met on the 25th of February, it was now devising a plan. Mustaq and Balkithun views are important because it means, particularly with Balkithun, that they were unlikely to be convinced about effecting or attempting a rescue of the divers from within the pipeline. Balkithun admitted in cross-examination that she saw people diving and she considered that it was her role to assist the IMT to try and see whether there would be willing divers to effect a rescue. She said she passed that information to Mr. Piper around 7 p.m.
Thank you. I see that there's a little bit to go. Is it worth taking a 5-minute break now?
Yes, yes.
Just to
Yes.
stretch our legs?
Much
Should we do that?
obliged. Much
Thank
obliged.
you very much. 5 minutes, please.
Yes.
Can I, just returning to my concern about the duty of care point, assume, as I say, for the purposes of this argument, that we don't find that there was a breach or any duty of care at the outset on part of Paria, right? But they set up an IMT, and to step away from this case for a moment, supposing there is an incident somewhere and an IMT is created, and that IMT makes a complete mess of it. As a consequence, people die. Would they be taking on a liability by creating the IMT and then messing it up? That they are, by virtue of the creation of this IMT, taking on a responsibility to act in accordance with its rules, and a failure to do so, which results in loss or injury or death, creates a separate liability?
Well, the incident management system was set up in order to prepare for an effective response in case of an emergency.
Right.
And if it is that they fail in that duty.
Is it a duty?
Well, I would think that it's a duty, because one has to also appreciate there's something occupiers liability.
Yes.
So therefore, I think it's a recognition of the duty of being in the position of an occupier at common law. So that
let's say they're not the occupiers. There's an IMT set up after a terrible tragedy takes place. An IMT is created, bringing together a number of specialists, whatever it is, it's created. And that IMT makes a complete mess of it. And as a result, people are injured and or die. Are they taking on a liability by virtue of the creation of this IMT? Quite separate from what caused the accident or the incident in the first place to give rise to the IMT. Might be a natural thing, a disaster, naturally occurring, or a ship, as I've described before, crashing into a berth. Nobody's fault, rudder was broken, and it just crashed into a berth. So the IMT is created, and the people in charge of that mess it up. Are they liable?
Well, if it is not an accident on the site, I think there are different considerations. But if it's an accident on the site, it brings in the common law principles of the duty under the occupier liability principle. And I could see that there could be an argument, but there could be an argument, and I would also include that aspect in the note I would send to the Commission. But it is I recognize that this is not an easy area of the law.
No, I
could understand that if I am a judge and I had to decide the point, I would express the same concerns or even more concern that you, Chairman, has been asking. But when one looks, and that is how law is developed, as the Chairman knows, one takes principles which have already been decided and try to fit them in. And that is how the law has been developed. So in my mind, when I was looking at these facts, I knew that these are some arguments that we maybe used against it. But I have always tried to use the principles of law to be able to fit a case if I can, and even if it means breaking new grounds. And I remember as a young lawyer, when I was in prison for contempt of court because I told a judge she was acting unjudicially. And most of the lawyers told me, you cannot sue the state. They even told me the conviction would be affirmed. I said no. And it was set aside. And then I sued the state to get damages. And the law was, the common law is, that you can't sue a judge. But I sued the state. So we told the courts, the upper courts, that I'm not going against the judge, I'm going against the state, the judicial arm of the state. And now that case is authority in the Commonwealth. So I know the principles of law probably are not yet molded, but I would like to take a shot at it because I believe that for the future, if you have an employer having works done on its premises and men are in a life-threatening situation, the employer must have a duty of care if it knows that if it does not act, the men can die. And this,
No, I think I don't think there's a difficulty about that. I think it's the extension of that as to whether there is a duty to rescue. That is what I think is troubling me more than anything else. I mean, a duty of care, yes. Duty of care that might continue into a rescue, yes.
well,
Arguably, but of its own bat, as it were, that there is a duty to rescue.
well, if there is a duty to take reasonable steps to safeguard health, there could be there's a greater duty to take reasonable steps to prevent that.
All right. Well, let's not. Let's look at the finer details of the law, perhaps separately from your submissions generally. But I mention it now because you raised it during the course of your submissions, and I am anxious to give everybody an opportunity to be able to make any submissions that they wish to on that issue. Particularly Paria, obviously.
Yes.
So I'll make a ruling about it afterwards, but let's hear your submissions. Yes.
So I go to that Mr. Piper knew since about 7:15 p.m. that there were competent LMCS divers willing to go into the pipeline and that there was commercial equipment available for rescue. Mr. Piper said that at some time during Friday evening, he knew that LMCS had equipment, commercial air supply equipment, experienced divers, and had divers willing to go into the pipeline, and yet took the position that it was not safe for them to go into the pipeline. In Paria's timeline, it is recorded at 6:55 p.m. the divers' diving equipment arrived at site. Mr. Piper said that even earlier at 6:25 p.m., that it was not safe for divers to go into the pipeline after Visham Harichan told him that LMCS divers were diving into the pipeline. Alvin Sitaram in his evidence confirmed that Subsea Global Solutions Limited had on board the Waterworld all the commercial diving equipment and lighting that was necessary for a rescue, and that the Coast Guard had inspected his equipment. He said that Waterworld had super lights, band masks, that is helmets, diving umbilicals, have high pressure, low pressure backup, air supply, umbilical lengths of 375 feet and 200 feet. Sitaram also confirmed to the chairman that while SGS divers were not available to dive because they had used up their maximum dive time in previous dives, that all the equipment was available for the divers to use for the rescue. Sitaram said that he was told that Ronald Ramuta had available divers who could have used the equipment to dive into the pipeline, and this was from about 7:15 p.m. on Friday evening. He also said that the Coast Guard was impressed with SGS equipment and confirmed to the chairman that there was nothing more than Paria could have wanted or desired in order to effect the rescue over and above what he already had. Paria's instructions were that no one was to be allowed to dive in the pipeline. Continued. I want to point out to the tribunal what Paria did in asking diving companies, and when those diving companies were asked. Mitchell was contacted on Friday at 5:05 p.m. by Royal Seals and at 5:23 p.m. received confirmation that Mitchell's would be able to provide its services, and I've put a reference. The Mitchell's team arrived at around 8:40 p.m. with service air supply equipment and were told to remain on standby, and I've put a reference in the evidence. After 1 a.m. on Saturday, Royal Seas asked Mitchell's to view the video footage of an underwater camera, and Fitzroy King said Mitchell divers were too big to fit in that pipeline, and Mitchell were told to stand by at about 2:45 a.m. on Saturday. Mitchell divers were told to stand down, and they returned to Mitchell compound at about 3:10 a.m.
So they were just not really used.
Eastern divers. Eastern divers was contacted at 11:40 p.m. on Friday. And at 12:30 a.m., some of its members arrived at Berth 6, with the full team being assembled at the compound by 1:25 a.m. on Saturday, and was briefed by the incident commander. Auntie Johnson said that the incident commander told him that due to the variables around the incident, Eastern should prepare itself for retrieval and not rescue, due to the possibility that the divers may have expired. After its assessment on the site, Andy Johnson told the incident commander that his team would not be able to make an entry to perform the rescue operations, as approximately 120 feet of the 1,200 feet pipeline was filled with water based on what was seen on the video footage. Eastern remained on standby by offsite for the next 12 hours from 5 a.m. Hull support. Hull was contacted at about 4:30 p.m., but was unable to mobilize a crew. Gayasi Woodley, who is Hull's operation manager, said that he had several discussions with Royal Seals, and Hull advised against cutting the horizontal section of the pipe as being too risky. OTSL. OTSL was contacted on Friday afternoon, and its dive vessel arrived at Paria at about 8:30 p.m. and remained on standby until 5:30 a.m. on Saturday, and was not called upon by Paria. HHSL and the cameras. HHSL was only contacted at about 10:50 p.m. on Friday by Michael Way. A pushrod camera with operating crew arrived from Atlantic LNG at 9 p.m., but that camera was not inserted until midnight. Colin Piper said that the pushrod camera actually came at 11 p.m. Then I have submitted that Paria did not get advice from Royal Seas and Fontes, persons they contacted in order to consider LMCS rescue plans. Paria had available to it Royal Seals and Krishna Fontes, who are experts in diving, to request either or both of them to have discussions with LMCS divers to consider their rescue plans, so that Paria and the IMT could have made a decision on whether to reconsider its decision to prevent LMCS divers from diving into the pipeline. Also, Paria could have attempted to contact the expert Mr. Zaid Khan in Incotec to give them advice as to whether there was a risk of another Delta P event after the pressure in the pipeline was stabilized. Such an expert could have also advised them about the risk of sending divers in the pipeline to rescue divers from the pipeline. And the chairman would recall that in questions to him, asked by you, Mr. Chairman, that if he had the information which Paria had, would he have given an evidence? And would he have given an opinion? And would that evidence would be to effect the rescue, to attempt the rescue? Paria used the diving companies on the evidence to support its unreasonable insistence on receiving conclusive video evidence of the inside of the pipeline. The evidence discloses that Paria became preoccupied and distracted by the cameras and video and ignored the information of Budram and Michael Kurban. In any event, the video, when it was eventually received, confirmed that the line contained clear water, not oil, or not so much oil. So much so much so that the model number on the tank pushed by the crawler was clearly visible. Summarily, the evidence discloses that the IMT on Friday evening, we say as early as 7:15 p.m., when SGS came outside offshore, there was commercial equipment for rescue. In fairness to Mr. Piper, he did say in his evidence that during Friday evening, he knew that LMCS had equipment, commercial air supply equipment, experienced divers, and had divers willing to go into the pipeline. Paria says that LMCS as the contractor was regarded as a first responder, a point repeated by Mr. Archibald in his evidence and underscored in Paria's opening statement. It is submitted that Paria had a joint responsibility with LMCS to take steps to first discuss the rescue plans to determine whether an attempt to rescue can be made. LMCS also had a duty to attempt a rescue, and from the evidence, they did attempt that, but was prevented from doing so. The next part, and I'm coming to the end, Mr. Chairman, the next part is that the fact that Paria failed to identify a Delta P as a potential risk meant that no emergency plan was developed, and I want to put that in the context of the rules. At paragraph 4 of Paria's HSE requirements for the contractor, all Paria contractors must conduct suitable and sufficient risk assessment or job hazard analyses or job safety analyses for all activities and for all work permits. At paragraph 7.0 of the same document, Paria requires all contractors to have emergency response plan for fire, gaseous emissions, spills, and any other credible scenarios. Moreover, at lines 2 to 4 of 7, this ERP will be reviewed by Paria's HSSE personnel for adequacy prior to the commencement of any work. So one sees from Paria's rules, Mr. Way's confirmation at paragraph 76 of his witness statement that Paria's maintenance department reviewed and accepted LMC documents, included its risk assessment, means that the risk identified by LMCS, which did not include a Delta P hazard, were accepted by Paria. This means that Paria wrongly did not regard Delta P as a credible risk. It also means that since Paria did not regard Delta P as a potential risk, Paria did not have any emergency plans to deal with the situation. Accordingly, when the situation occurred, neither Paria nor LMC recognized the root cause of Delta P, and because neither identified Delta P as a potential risk, neither had an emergency response plan to rescue the divers. Certainly, Mr. Khan's view is that Delta P was a credible risk, and it is said that since both Paria and LMC failed to identify as a risk, no steps were taken to eliminate this hazard were implemented. OSHA agreed with the Commission. OSHA agreed with Mr. Khan's opinion, and at paragraph 5.3 and 5.4 of OSHA's preliminary report, it said that neither Paria nor LMCS emergency plan captured emergency scenarios in relation to LMCS. This was a scenario specific to the job, and for Paria, scenarios based on a risk assessment. It follows, therefore, contrary to Mr. Y's evidence, Delta P was both a credible scenario required to be documented in an emergency rescue plan approved by Paria and should have been included by LMCS in its emergency plan following a suitable and sufficient risk assessment. Paria's failure to insist on this inclusion of a Delta P as a credible scenario, which should have been part of LMC's emergency response plan, meant that Paria's HSSE personnel did not carry out a proper or adequate review of LMCS documents. And then I come to the treatment of the family. The families of Rishi Nagesa, Yusuf Henry, and Faisal Kurban were in the car park outside Paria's compound from Friday, 25th February, to Sunday, 27 February, seeking information on the rescue efforts. Both the families of Rishi and Faisal indicated that they were informed of the decision to transition to recovery on the news on the evening of Sunday, the 27th of February, 2022. The evidence of LMCS is that they had difficulty in contacting Rishi and Yusuf families, but they gave the contact details which they had to Paria. Paria's evidence is that the families were updated through a meeting at the staff club on Saturday, the 26th of February, 2022, and thereafter by way of WhatsApp. Mustaq Mohammed's evidence is that the families were informed of the decision to move to recovery on the evening of the 26th of February by him via WhatsApp. In cross-examination, Mr. Mustaq Mohammed stated that arrangements were made to accommodate the families on Saturday afternoon, that is 24 hours after the incident. The first time that Paria met with the families was on Saturday, the 26th of February at the Pointe-à-Pierre Staff Club. Before this meeting, Mr. Mohammed says that he did not know that the families were in the car park since Friday afternoon, trying to get information. Mr. Mohammed said that he wouldn't argue the point and conceded that this was not an acceptable position.
Yes, well, I've made my position clear, I hope, that whatever else might have happened, this was woefully inadequate and frankly uncivilized. Nobody should have to sit in a car park waiting for information for 24 hours when their loved ones are in an incident like this. And I'm afraid I hold everybody responsible for that. It's not just Paria. It is an unacceptable position to be in. I just simply do not understand the humanity of that. I just don't.
Mr. Chairman, before I pass to recommendations, I just want to submit that the inevitable conclusion from the evidence about the rescue, which has been produced in these proceedings, is that the hours between the time of the incident, the hours of the time between the incident when it occurred and the early hours of Saturday morning, from the evidence, were in effect squandered by Paria to attempt a rescue. This is a time period in which the men were most likely to be alive. And as each hour passed, the possibility that they were remaining alive became less and less likely. So I will go to recommendations.
Thank you.
I know one of the terms of reference is for the commissioners to make recommendations, and we have a few that we want to submit. Companies like Paria, which undertake inherently dangerous works, ought to employ a client representative or engineering expert to assist in the preparation of the scope of works, to review and accept the contractor's documents, and to oversee the execution of the project by the contractor in accordance with the permit to work procedure.
Should that always be an independent person, or could they have employed someone themselves within the firm?
They can employ someone, but provided the person is suitably qualified.
Right. So it doesn't have to be independent.
No. Next one, persons performing the roles and responsibilities set out in the permit to work procedure ought to have dedicated training and qualifications to enable them to perform the functions in those roles in accordance with the permit to work procedure. Now, we have seen in the evidence in this inquiry that has not been the position. The client representative or engineering expert should be empowered to coordinate the various aspects of the project under supervision of the general manager to ensure that the company's objectives to create a safe system is achieved. The permit to work form ought to be clear and unambiguous, and the responses ought to be clear and unambiguous. It ought to be redone and fit for the purpose.
I mean, your position is that it's not fit for purpose at the moment. The way in which it's set out on a single page as it is, it's
inadequate.
Yes, it
insufficient.
needs to be fuller,
Fuller
with a little more space to put the necessary
in order to
entries.
put in, yeah.
Yes.
The permit to work form ought to be clear in prioritizing the task, including sequence of the task, and it ought to be contractually underpinned. Work instruction should be clear and unambiguous and required to be co-signed by the applicant and the contractor. Consideration ought to be given to amending the permit to work procedure so that a permit to work would be issued for specific tasks which are inherently so dangerous that they should be given special treatment. This permit to work would only be issued after the issuer is satisfied that the toolbox meeting was convened in relation to this task and the risks were discussed and the control measures understood and agreed. There should be clearer guidelines in the permit to work as to the meanings of periodically and continually.
Yes.
In this case, it was the duty of the applicant to continually monitor. However, he did not arrive on the site until 2 p.m. on the 25th of February. Therefore, there was no monitoring by him at all prior to that time. Every risk assessment or job hazard analysis with respect to any project dealing with subsea works ought to address what we regard as an obvious risk of Delta P.
When you say subsea works, you mean, do you buy that in relation to pipes?
Pipes, yeah.
Yes.
Pipes.
I mean, you could be subsea work.
We should
where-
specify it. It should be
yes.
pipes. Pipes. There should be a section in every risk assessment under which the hazard is considered and a specific control measure identified. Measures identified. The incident command system should be reconfigured to address operational emergencies, which may be regarded as exceptional. This would assist with the development of an action plan, specifically identifying the control measures of what resources are necessary and what resources are necessary to conduct any rescue. I couldn't understand that in a company like Paria, you didn't have an emergency response plan in order to respond to a Delta P event, and with so many pipe works being done. So I think if you have
I mean, even if outside of the specific job, that there should be in existence a separate emergency response where Delta P has arisen as an incident.
Yes, Mr. Chairman. Under the incident command system, there should be more regular training and drilling, and the ICS respectively audited, and should be periodically audited.
Yes.
It should be periodically audited. Consideration should be given to the establishment of a rotating incident commander, so that depending on the nature of the emergency, the most suitable, trained, qualified, and experienced incident commander would be automatically appointed.
Yes.
High-risk activities should be scheduled only on those dates and time when the key members of the incident command team are on site. On this day in question, for some reason from the evidence, all the important persons seems to be away from the site. I don't know what was happening.
It was pointed out to me by Mr. Peterson. This was carnival time.
Oh, it's carnival. Sorry, but there was no carnival on that.
Yes, there was a taste of carnival.
There was a
Yes, there was an event. And those of us who party, a taste is as good as the whole meal.
I'm going to take Mr. Peterson's word about that.
I would also take his word for that. But he's the authority.
But I mean, it's a fair point to make, though, isn't it? That really, should you be carrying out works of this kind when people are away for whatever reason?
And then the next one, the protocols for the establishment, training, and drilling of the ICT should be accessible to regulators and periodically updated and tested. It should be supported by an active communication team, which will ensure, without the need for direction by the incident commander, that victims' families can be accommodated, supported, and communicated with on a timely basis. Consideration should be given to having OSHA regulate the operations of the incident command system. And this includes OSHA regulating the composition, training, procedure, and drilling of the incident command system, and requiring these to be certified annually as fit for the purpose. There are no compulsory diving standards in Trinidad and Tobago. There are, however, voluntary standards which have been issued by the Trinidad and Tobago Bureau of Standards. However, those standards have not been made compulsory due to a lack of consensus among the stakeholders. Also because they are voluntary, they are not enforced. So consideration should be given to be looking at this.
Were they even used in this case?
Yeah.
Were they even used here? The voluntary standards, it seems to me, were not even adhered to here.
And no, they were not used. Accordingly, it is recommended that Paria and similar companies adopt and maintain international best practice in relation to commercial diving, in relation to its subsea repair and maintenance jobs on pipelines.
I mean, they could have done that anyway. They didn't need to have statutory regulation. They could have voluntarily had such a requirement for anybody bidding. I mean, we've seen the voluminous documents that they've created, but they could have required, could they, that the company should have at least the voluntary standards imposed by the Trinidad and Tobago Bureau of Standards. But they didn't.
They didn't. And then the Trinidad and Tobago Bureau be invited to prepare, implement, following stakeholder consultation, a compulsory standard regulating the commercial diving industry in Trinidad and Tobago. OSHA implement regulations so that international best practice can be implemented in relation to the health and safety on the subsea worksite.
I mean, OSHA could do that at the wave of a wand, couldn't they?
Could, yes.
They have the power
have the
under the
power.
Act to be able to introduce regulation for any particular field of endeavor in this country, where they think that such regulation will be for the benefit of those engaged in it. They've been in existence for 18 years, have they not? The
Yes.
agency and the authority under the Act, and still no regulation for something as fundamental, perhaps, in a country which has an oil and gas industry. And I might, in passing, also observe that whilst Paria didn't impose the standards that were said to be voluntary by the Trinidad and Tobago Bureau of Standards, neither did LMCS adhere to such standards.
No. Correct, Mr. Chairman, that is correct. In pipelines less than 48 inches in diameter, that consideration be given to augment existing pipelines and for all new pipelines to be configured to permit, particularly at the elbows, an additional installation or design to permit divers to be able to turn around. The
Right.
Accreditation Council of Trinidad and Tobago be appointed an accreditation agency for commercial diving in Trinidad and Tobago for amending the Accreditation Council of Trinidad and Tobago Act, Chapter 3906.
This is creating a sort of teaching environment
Teaching environment.
for commercial diving in Trinidad and Tobago, and that there should be some accreditation, more formalized accreditation.
Formalizing,
Yeah.
yeah.
All right.
And then I come to OSHA's powers to prosecute under the OSHA Act.
All right.
Having regard to OSHA's preliminary report, which suggests that both Paria and LMCS may be guilty of various offenses under the OSHA, the commissioners may consider, based on the evidence, to recommend proceedings by OSHA. Section 91(2) of the OSHA Act permits OSHA, following an accident in an industrial establishment, and where it appears from the commission's report that the OSHA Act was not complied with, to bring summary proceedings against a person liable to be proceeded against in respect of such non-compliance, and those proceedings are required to be commenced within 6 months after the making of the report. The OSHA Act imposes duties on employers, occupiers, employees, manufacturers, and suppliers of goods. Some of these duties are owed not only to persons working at the industrial establishment, but also to visitors and persons who might be affected by the activities carried out at the industrial establishment. Section
Can I
86.
just pause in there for a minute? The Act itself requires the agency created under OSHA to act if they see it appropriate to bring a prosecution within the 6-month period
Yes.
in the magistrate's court.
Yeah.
And that applies to individuals, does it, as opposed to companies or both?
Yeah, it applies to employers, which could be a company or an individual.
Where it says to bring summary proceedings against the person liable. Do you mean by that the company,
The company.
and or the individual if it's,
Yeah.
if I've employed someone and
Yeah.
it's called,
So
right,
it must be the employer.
right. So when you say the person, you mean the employer?
Yes.
Right, thank you. I'll change that. So, just a moment. And that gives it, well, certainly in magistrates' court proceedings have to be brought within 6 months. But my understanding of the Act allows this commission to, if we chose to do so, to recommend prosecution. And the timeline starts from then rather than the original Act.
Yes.
So this happened on the 25th of February. Ordinarily, that would have expired in, my maths is right, August. But because a commission of inquiry has been established, we have the power to, as it were, if we were to make such a recommendation, for the 6 months to run from the date of that recommendation.
Correct.
Crucial in that, of course, is that once we hand in our report, assuming it is at the end of this April, the time runs from then. And the government need to be aware that timely disclosure of the report so that OSHA could act on it if they chose to do so, will run from that date.
Yes.
So any delay in disclosing the report generally, and in particular to OSHA, may result in the time being time barred.
Yeah.
Yes, thank you very much.
I don't know whether it's section 86.1.
You dealt with section 86.
Yes.
Or you're just coming to that, yes. Just coming to section 86 of the Act.
Yes. Section 86.1 of the OSHA Act
Yes.
states as follows: subject to subsection 2, where a person dies, is critically injured, or develops an occupational disease in consequence of an employer, occupier, or owner having contravened this act, the employer, occupier, or owner shall, without prejudice to any other liability or right of action arising out of the death or critical injury or disease, be liable to a fine of $100,000 or an amount equivalent to 3 years' pay of that person, whichever is greater, and the whole or part of the fine may be applied for the benefit of the victim or his estate, or otherwise as the court may determine. What is our recommendation?
It's not very much.
No. So I think we should have, we have recommended that should be looked at, because the evidence here discloses breaches of the OSHA Act as employer of deceased or injured divers, and by Paria as occupier of Berth 6.
Of course, you'll appreciate that it is no part of our remit to recommend prosecution as such. What we can do is to identify the facts
and for
and
OSHA
recommend,
to consider.
For example, either the DPP or OSHA consider whether or not an offence has been disclosed.
Yes.
It is not part of our responsibility to say, LMCS are guilty of some crime or Paria are guilty of some breach of the Act. It doesn't lie in our mouths to say that. It is our responsibility to simply report the facts as we see them, and then to invite any of those agencies to consider whether or not they wish to prosecute.
Yeah. Because we do not have the power to recommend prosecution.
No.
That is a function of the DPP and the police.
There are other persons
and the
responsible
most
for
that I think a commission can do is to recommend that you're sending the papers, depending if the report is accepted, you're sending the papers to the police or the DPP for investigation,
Yes.
further investigation.
Or OSHA, or OSHA, who are a separate
Yes.
prosecuting
Oh,
authority.
yeah.
Yes.
I think since this is a public matter, I have a duty to deal with Mr. Ramadan's submissions. So I just want to say, Mr. Ramadan, on behalf of some of the relatives of the divers, raised the issue of the commissioners making recommendations for criminal prosecution from the evidence which is before the commission. That issue has been engaging the attention of the legal team, but we are not prepared at this time because we have not completed our research on that. We would have the research completed within the next 7 days. The law in this area has been developing. There's a decision in Trinidad and Tobago in the case of inquest number 10 of 2008, in the inquest into the death of Mayo Oliver. But I want to make it quite clear, any opinion I give to the commission is in law private and confidential. And it would not be made public, and it would not be put up on the commission's website.
Quite so.
That would be a private and confidential document in my duty to assist the commissioners in considering the matter.
Well, I think advice that you're giving us is something that ought to remain, in the first instance, certainly confidential. Whether or not I would permit other parties to the proceedings to know what your submissions were seems to me something I would have to keep an open mind to. I think there is a distinction between specific advice to us as commissioners and a submission as to a course that we should adopt.
I agree with that.
And one needs to draw a careful distinction between the two. If it's a submission, then I do think that the parties ought to be able to see what it is that you're submitting.
It's purely a legal opinion.
Yeah, if it is a pure legal opinion, well, as I say, I will. I understand that's what you're intending to do, and I will deal with a couple of these matters in a moment when you conclude. But what I'm not going to do, obviously, is to disclose what is simple advice between counsel to the commissioner and the commission, as opposed to a submission as to what we ought to do or ought to consider doing. And if it's the latter, then I will certainly make sure that it's available to other counsel in the hearing.
I'm in total agreement with that.
Thank you very much. All right.
Mr. Chairman and Commissioner Wilson, if there's anything else I can assist, those are my.
No, thank you very much indeed. I'm very much obliged to you.
So, Chairman, if I could just add by way of the last point as to the law.
Yes.
I think if my learned friend assists the commission on the law in a particular area that touch on concern and applies to the evidence in the case, I think we are entitled to see it. And because we may agree with my friend on the law, but with respect, I know that we are not entitled to, if my friend would advise you that as a chairman of a commission, you can impose your own procedural rules, for example. We're not privy to that kind, we're not entitled to disclosure of that kind of thing. But if it's on, for example, the law on a particular point with respect to the evidence, duty of care, all of those things, law on that.
Right.
I think we ought to know what a tribunal is being.
Well, you've heard what I've had to say about it, Mr. Peterson. I am not going to shut anybody out from what might be a submission. And certainly I would regard any submission made in writing by any party as being disclosable to others. I think it's quite a different matter if on a more complicated area of law, we are to receive some advice from our counsel to this commission. That would not ordinarily be disclosable. But I will take it on advisement. You have understood from the outset of this inquiry, I have been as open and as public about every aspect of it that I can be. As has already been pointed out, I don't think there's a single document that has not been disclosed other than those which are obviously sensitive and redactions of people's addresses and telephone numbers. Otherwise, every single piece of paper that we've considered, you can consider, and indeed the public can consider. This is a public inquiry. Why shouldn't they? Aside from personal matters, embarrassment or features of that kind, as far as I'm concerned, have nothing to do with it. So the public have complete access to all of the material that we have. All right. Can I deal first of all with the two matters that have arisen during the course of my learned friends, the council's submissions? Reference was made to a response by Mr. Mushtaq Mohammed in an email to, in a letter, to OSHA, dated the 20th of July of last year. I think it right and appropriate to give him an opportunity to respond to that letter and the criticisms made of it, that it seems on its face to be inconsistent with other evidence that we've heard in the course of this inquiry. What I propose to do is to make a ruling that he be given until the 20th of January of this year to respond in writing to Ms. Sinanen, who sits behind me, so that we can consider it. I will have it over that weekend. I will then cause it to be published on the website for the 23rd of January of this year, and invite anybody who wants to respond to anything contained in it or make any submission at all in relation to it, including counsel for Paria, to do so by the 30th of January. All right, so that gives us a window of a couple of weeks or so from now for Mr. Mushtaq Mohammed, if he chooses. I don't order him to do so. If he chooses to respond to it, he can, and any counsel will, from the 23rd of January, be able to access it on the website and be able to respond to it. All right, so
just by way of clarification, so I think Mr. Maharaj dealt with a particular paragraph to that letter.
Yes,
so
it's a letter dated that,
I got the date already, so that's the
right,
20th of July.
In which there are a series of questions being posed by OSHA, 11 in all, and responses being given by Mr. Mushtaq Mohammed on behalf of Paria Fuel.
But the contention was with respect to a particular question, I think.
And what's been identified is paragraphs 4 and 5 in
4 and
particular.
5. Right.
But as I say, since none of this was formally asked of Mr. Mohammed, and given the criticism that's being observed by it, he has liberty within the course of the next 7 days to respond to that criticism. As I say, I don't order that he should, merely that he has the opportunity to do so, and it will be taken into account, all right? Now, that's the position with that. As to any submissions, I raised during the course of the arguments proffered by Mr. Maharaj on duty to rescue. Again, I do not order anyone to provide anything in relation to that at all. But if anybody does wish to make a submission about any duty to rescue that might arise either from an IMT or on the part of LMCS's responsibilities in having a rescue plan, any duty that might or might not arise, I will I will receive any submissions on that by the 30th of this month. Right, so by the 30th of January, please, if anybody wants to. I don't order anyone to do so, merely that if they wish to do so, they can. But that's the cutoff, the 30th of January, please.
Just by way of clarification on that, sir.
Yes.
The 30th, we reserve, because of the point I made yesterday at the opening of my closing, if the commission gets to the stage where they wish issue letters to us, then I think it would be prudent for us to respond at that time.
Well, it's a matter entirely for you. If you want us to consider any of those issues in advance, we will. Yes. You'll need to make that submission by the 30th of January. If you wish to hold your powder dry, should it be necessary to do so, if we issue salmon letters, then of course the purpose of issuing them is for you to be able to respond to it. And if there is contained in such a letter any duty which we raise as a prospect for you to consider, then of course you'll be able to deal with it then.
When I check my powder stock, if I have enough to fire twice, sir, I may do it.
All right. All right. Thank you very much. So that deals with those matters. I'll make sure those rulings are put up on the website. Can I just say, as we draw to a close, Mr. Maharaj, a few comments, please. Both from me and Mr. Wilson. Certainly for me, on the 6th of July, I was asked by the President to chair this inquiry. Mr. Wilson some months before that. But today, just 6 months after being so instructed, we have concluded all the speeches. We have concluded all of the evidence. That would simply not have been possible without the considerable cooperation of everyone. My team, headed by Mr. Ramesh Maharaj, has been exemplary, working, I can tell you, tirelessly on the evidence to have it ready for these hearings. The backroom staff too, some of who sit here but working in the back, have played a significant role in ensuring the smooth running of this inquiry. Above all, Sarah Sinanan, and I don't spare her blushes, has been significant, frankly magnificent, in putting together this inquiry for us all. It simply would not have happened without her. I have to say, she has no administrative skills that I know of prior to joining us as a team. She's demonstrated an extraordinary ability to be able to find ways around all of the obstacles, some of which I've expressed previously, that have been placed in our path. I wish I could take her with me. She's been fantastic. But neither would it have been possible without all of your cooperation. Sitting here very late some days, much to the consternation and chuntering of some, but we've been able to achieve the timetable that we set, which was an ambitious one, but we have been able to do it, and it simply wouldn't have been possible without all of your cooperation. So I want to thank you all, and indeed thank you for your courtesy and assistance in us being able to reach the stage that we have now. I should like to say also something about the public. Thank you, all of you, for making me feel personally welcomed in this country and valued. All too often, I've been stopped in the street. People have come to me and said, "Can I have your photograph?" It's been slightly embarrassing from time to time, but it has been rewarding to think that the efforts that we, Mr. Wilson and I, have put in are appreciated by the population at large. So I thank you all for that. It is good and gratifying to know that the people of Trinidad and Tobago have so readily taken to me, this foreigner, who has come to exercise my best abilities in this inquiry. What I will say to you all is that we will continue to work hard to ensure that and produce a report which everyone can be proud by April of this year. It will, of course, be a matter for government to determine when it is made available to the public. But I know that Minister Stuart Young is anxious to make this as available as soon as is possible. And I shall be doing all in my power to apply such pressure as I might be able to bring to bear, if that be necessary, to ensure that the public have a copy of this report as soon as it is possible to do. Whatever our ultimate findings, it will not have been driven by rumor, superstition, or emotion. It will have been driven by the evidence that we have heard and read. We will not lose sight of the fact that Kazim Ali Jr., Rishi Nagasar, Youssef Henry, and Faisal Kurban lost their lives, that Christopher Boudram continues to and remains scarred by the events that took place on the 25th of February of last year, that family, friends, and those who are the loved ones of those who died remain scarred by the events of the 25th of February last year. You will have a report. It will be ready by April. Thank you all very much indeed. And I ask the counsel to join me briefly in the witness room at the back of this courtroom. So thank you all very much indeed. That is it. Thank you.
Thank you for watching, but do stand by as we play the memorial video that I would have prepared with my colleague, Riyad Khan. So just stand by for a second as we play the video.
So I moved.
I'm going to start back that video because I heard that there is no sound. Okay, so let's start the video again. This is the tribute video for the divers. So one moment, please.
So I moved against my inner instincts that there should be criminal prosecution recommended.
Representing some of the families of the deceased divers, Attorney Prakash Ramadan in his closing statement said he had no choice but to make a recommendation for those responsible and held accountable.
What is a recommendation? I am there because of the persons who expressed the need for us to set an example, to set a new standard in the society. If we do not, then it is likely to be done.
Everything inside you will be rescued. No one will be granted. You know what I mean? At such a stage in my life, I lost one of my siblings.
Paria's multiple decisions to violate the right to human life and the right not to be subjected to cruel and inhuman suffering remain unconscionable. Paria made these decisions as those inside the pipe continued tapping out distress calls well into Saturday. They heard tapping. They heard SOS code. I heard Cousin tell them to respond by tapping back so they would know they were heard. He said, tap louder and see if they tap louder, and then tap softer to see if they tap softer. They subsequently informed Cousin that when they tapped louder, a louder tap was returned, and when they tapped softer, a softer tap was returned. For me, interactive communication was established, conveying that the divers were alive. The tapping transmitted meaning, and the divers in the pipe were making SOS sounds and wanted to live.
Sorry, give me a moment, please. So I just, before we depart, I would like to say a prayer with you. And so I'm going to be reading Psalm 121 and followed by a few statements. But one thing I would like to take a moment to say is that their tappings have indeed been heard. And this Commission of Inquiry and our interest in finding justice is just beginning today. And so I read Psalm 121 as I move to so do. I lift up my eyes to the mountains. Where does my help come from? My help comes from the Lord, the maker of heaven and earth. He will not let your foot slip. He who watches over you will not slumber. Indeed, he who watches over Israel will neither slumber nor sleep. The Lord watches over you. The Lord is your shield at your right hand. The sun will not harm you by day, nor the moon by night. The Lord will keep you from all harm. He will watch over your life. The Lord will watch over your coming and going, both now and forever. The reason I share this prayer with you is that we've been on a journey together. And while this might not be our blood family, they are indeed our brothers in our hearts. And so, in sympathy, we embrace all of the families of Faisal Kuma, Yusuf Henry, Rishi Nagasa, and Cousin Ali Jr. And in sympathy with our hearts, together we call for justice. Such loss can indeed seem unbearable, the pain lasting forever. But this pain is a rallying call for us, is a rallying call for us to ensure that our government does what is right by these divers. Our government, when that report is lays that report just as lynches them for the public. And if prosecutions are necessary, we pursue that to the end. And so it is at these times a family, citizens are brought together. The strength that we have built over these last 19 days of this commission of inquiry has found in us a yearning and a unity, has found in us a renewed sense of hope for justice. And the memories of happier times, the memories of life, the memories of Faisal Khan, Yusuf Henry, Rishi Nagasa, and Kazim Ali Jr. shall not go waste. We remember our brethren with love, and we pray for peace and healing to the families concerned. And so I leave you with this prayer. And I hope that as we move forward, we go so with peace, love, and with a heart for justice. And may these families get the justice that they deserve. God bless you. And thank you for joining the stream, everyone. Thank you.